Okay. Except for eviction, all other prayers for mention, please give it to the court master.
Ma'am, please, I beg to mention item number 14, Lord, say,
Just,
on behalf of RK Doctor also.
just,
And 15 also are already, Lord, say.
just a moment.
14, Lord.
Which item?
14, 1-4. 14 and 15 both are taken matter, Lord, say. Okay, consent already taken, Lord, say.
Okay.
Adjournment memo also be submitted.
Okay, you are for?
I am for petition also, on behalf of RK Doctor. KD Sharma.
Okay. With consent of the other side, Mr.
KD Sharma.
KD Sharma, counsel for the petitioner, prays for adjournment. It is allowed. List after?
1 week, Lord. 1 week.
List after a week is prayed for.
Made visual also.
Yes.
So item number 58 of today's supplementary list. I am seeking for some accommodation in that matter also today. I am led by Mr. UK Nair in that case. He has some difficulty today. I have taken the concern of the other side. Can it be on Friday?
54.
58, Lordship.
58.
Supplementary motion.
Okay. Okay. Consent of the other side, Mr. A. Sharma, counsel for the petitioner, prays for adjournment. There is allowed. List on so. Yes, Mr. Margo.
It is for listing on Friday, madam.
Give to the court.
My lord, I beg to mention for listing, my lord, on next 19, my lord, next month.
Please give it to the court master. You have heard me. Please give it to the court master.
Actually, IA 1502 2003. My lord, actually, this was with for interim injunction. But then we have filed registration was done on 30th of this month, but then till now, last month, but till now.
Give it to the court master, please. Please try to understand.
Well, I beg to mention item number 46, my lord. This order has been passed by my lord, just escape making, my lord. There is typographical mistake. For correction,
Okay.
it has come. Let it come on 14, my lord.
Okay.
Before the
This interpretive application filed for correction of the order before the appropriate bench on 14/6/2023.
May I please, lordship?
Yes,
Lordship, I beg to beg for listing.
I am refusing.
Lordship,
I am
last-
refusing, not today. Make
last
a
week-
mention tomorrow. You have heard me 10 times. I have told that give it to the court master, and still you are moving. Now I am refusing now to you. If you don't be attentive, I am not allowing.
Apology, lordship.
It's not a question of apology. 5 times, 6 times I have repeated not to give it to me, give it to the court master, and you don't listen. What is the point in my making a statement when you don't listen? I am refusing. It will not be taken up.
Item number 1 for motion.
Yes.
May I please also? Mother password for the time being, Mr. Dana did some Lexi code number 1, madam. Here's some.
Just a moment. Okay, after some time. Let the government. Oh, yes. Yes.
I got the instruction.
Well, I have got the instruction from the department, my lord.
It has been refused.
It has been refused. Kindly come to page 17 of the petition, my lord. Page 17 of the petition, the first prayer, my lord. Prayer made is that the Director of Vigilance and Anti-Corruption, by its letter dated 13/1/2021, has sought for the approval of the government for holding an inquiry, my lord, against the person. Plus that the government appropriate authority has considered and they have refused. His grievance is that letter of the vigilance is pending before the government. Government is not taking any final decision. Now the decision has been taken.
You filed by way of an affidavit so that he understands.
Lordship,
He can respond to it.
Lordship, fine.
Since it's coming up in motion for quite a long time,
Correct, my lord.
I'm issuing a notice and then we'll take it up in
Yes.
commission stage.
Yes, Lordship.
You'll file it within a week.
My lord.
And you provide your email address to the government advocate so that you can be given.
Yes,
A copy.
we'll serve him copy.
For the petition person and Mr. D. Nath, senior government advocate for the state.
I'm
Yes.
appearing for 1, 2, 3, and 4.
In view of the nature of, so 1 to 4. Who are the others?
For private respondent number 5 is there.
Oh, okay. 1 to 4. In view of the nature of grievance residence is present in patient, if you notice a motion returnable in. We have to give notice to 5 also. Within 4 weeks. Requisite extra copies of the petition served on the London senior government advocate in course of the day. Next, the petition shall take steps within 2 days for service of notice on the respond number 5 by registered post with AD. The petitioner in person is permitted to collect the postal incident number and to submit postal track report prior to the next step of the stage. Next paragraph. Person to previous orders of the court. Comma. The London senior government advocate has produced instructions from the political within bracket vigilance cell, bracket close department, to inform him that with the approval of from the competent authority, the Directorate of Vigilance and Anti-Corruption from Assam has denied to grant approval for prosecution of the petition. Sorry, respond number 5. Yes, sir. Then we said details of the meeting form of an affidavit. Maybe filed in form of an affidavit within a week. Service of copy thereof by email to the additional person who will provide his email address to the London senior government advocate. Instructions for this are written.
But since Lordship has issued notice in 4 weeks, now,
4
we'll
weeks.
file within 2 weeks.
2
Some
weeks.
some more time. Within 2 weeks.
It's not due.
But-
You give a copy, email
Yes.
address.
My lord, I am appearing as a petitioner in person, so it is not possible for me to get the dates of the court. So please fix a date.
After 4 weeks, we get it. 19/7.
Well, the issue of maintainability, that may be kept open. Issue as regard maintainability, that may be kept open.
On the prayer made by Then a senior government advocate, the issue of maintenance is left open.
Okay.
It's kept open.
Okay.
Yes, Mr. Waterwood.
Please, my lord, I'm waiting on the instructions of Mr. S. Border. Your lordship, the subject matter of this case has become infructuous, your lordship. We want to withdraw the petition because the accounts have already been disclosed.
Okay. Mr. S. Dale, counsel, appearing on behalf of appearing on instructions of Mr. S. Waterwood, counsel for the petitioner. Yes. Submitted upon instructions that the matter has become infructuous and according to his instructions to withdraw the same. Mr. S. Chairman, standing also for the respondents. You are for all?
Yes, sir.
For respondents, my question is dismissed from withdrawal.
Most of them.
Whether this matter will be taken up after some time.
Yes.
Lordship, here the petitioner were found to be having dealing in fake business and thereby incurring a loss to the state revenue. And lordship, on the last occasion, they were directed to appear on 30th May before the tax authorities. They have not appeared, lordship.
Not appeared.
They have not.
None appears in call for the petitioner. Mr. Beach or the standing also for the state GST is present. And submits that person to order dated 15/5/2023 passed by this court. The petitioner had not appeared before the competent tax state GST authorities on 31/5/2023. Just just received an arrest with John today. It is made clear that if the petitioner remains absent on time on the date, adverse orders may follow. List after 2 weeks.
Here also, lordship, they were directed to appear before the time. No, they appeared, lordship, and they paid 1/4 of the tax and liabilities. But they have and gave assurance that by 10th of June, they would be paying the rest of the money, but they have not paid. It's comes around 5 crores something. Lordship.
Now appears on call for the petitioner. That's what, how is that? Each of the like standing also for GST, state GST is present. And submit that pursuant to interim order dated 15/5/2023, passed by this court, the petitioner had appeared before the GST authorities and have deposited 1/4 of the
Tax penalty and liabilities.
tax penalty and liability. However, although the petitioner had
They had given an assurance
They given an
that
assurance
by
that-
10th of June, they will be paying, but they have not
given an
paid.
assurance that by 10/6/2023, they will be paying the balance tax penalty. But as per his instruction, the same has not been deposited. First of all, Rangers received matters to adjourn today. List up to 2 weeks. Saying if petitioner remains absent from the next day, adverse orders may follow.
6. Can this matter kindly be taken up tomorrow, your lordship? If the airport board has.
Tomorrow is a Tuesday.
Lordship. There's some urgency because your lordship, the matter pertains to eviction. Your lordship.
Okay.
Only thing that, my lord, in the meantime, my lord, an identical writ petition pertaining to the same area, my lord, has been dismissed by the Honorable Court. My learned friend can take note of the order, my lord, so that he's also prepared by tomorrow. WPC 4775 of 2022, my lord.
And how's your son now? I'm told that you
My
are.
lord. Better
Hello.
now, my lord. Yes, come there.
On behalf of Mr. S. Bottle, counsel for the petitioner, Mr. S. Day, counsel for the petitioner. The learned counsel pays for adjournment. Mr. P. N. Goswami, learned additional advocate general. Appearing for the forest department, submits that an identical writ petition being WPC
4775 of 2022.
4775 of 2022 were dismissed by this court by order dated 9/5/2023. So the learned counsel for the petitioner may take note of the same. Give tomorrow. Distance.
Obliged.
Most of it.
7.
I am extremely sorry, Lordship, in item 54, Lordship. We have filed one additional affidavit that is not.
Get it.
Yeah, please, Lordship. Item 7, password for time being, Lordship. Licensure is timing, Lordship, we need to get some. Is not for time being. Password for time being.
My lord,
I'm sorry.
I want to issue a notice at this stage.
My lord.
I want to issue a notice at this stage.
The only problem is, my lord, now they are distributing the houses. So our case may be considered that observation, right? Because our application is pending before the project director.
Mr. J. Amit and counsel to the petitioners. Miss. Your name, I forgot. 7. Your name, I always forget. And Bora, standing also for PNRD department.
1, 2, 4, 5, 6 and 8.
1, 4.
1, 2, 4, 5, 6 and 8.
Okay, 1, 2, 3, 1, 2, 4, 5, 6, and 8. And Mr. C.K. Baba, and government advocate appearing for response number 3. And Mr. Ekanath, counsel appearing for response number 7. Claiming non-inclusion of the name of the petitioner in AAY of the PHH. No, sorry, IAY. Despite being a person with AAY of the PHH ration card. The present petition has been filed under Article 226 of the Constitution of India. Sorry, PMAY-G, not AAY. PMAY of the G, dash D, G. You should notice a motion available in 4 weeks. Requisite extra copies of the petition be served on the State and Department of Council in course of the day. Next, pendency of the petition shall not be about to examine the claim of the respondent authorities to examine the claim of the petitioner.
My lord, I'm sorry, my lord, I have actually my item is 9. My lord.
Oh, actually, not here, not in 7. So 7 notice has to be issued. 7. Petition shall be accepted within 2 days for service of notice on response number 7. Registered post to be reviewed. Yes.
One observation level. Our claim is pending before the project director. You may
I've said that
look into
competent
that.
authorities will examine your claim.
And if possible, 21 get reserved one.
No, I'm not reserving. These things are not to be reserved.
8.
Lordship, in this matter, we were asked to take instruction. Since the DFO is transferred, we just need a week time in Lordship. Maybe on Friday, your Lordship may fix. We'll take up the instruction, Lordship. The change in DFO, your Lordship.
Okay.
My lord, the basic facts are.
Just a minute. You are wanting renewal for when to when?
My lord, 22 and 23, my lord. For 2 years, my lord.
But they have done it for 23. They have said that to be renewed.
May be renewed, but they have not renewed. My lord, to find page
So
30.
what is the term of license from when to when?
My lord, 1 year, my lord.
From when to when?
My lord, page 30, my lord, would kindly see, my lord.
So
Page
this will be
30.
the date from when to when?
My lord, last it was renewed till, my lord, 31st of December 2021. It's from January to December, my lord. Page 30 is the last renewal, my lord.
Then let me issue a notice this. Otherwise, when it comes in motion, but this is A. Then counsel for the petitioner, and Mr. R. Govind, and standing counsel for the Forest Department, and Mr.
AD Sharma on behalf of S. Lordship. That's
Yeah.
number 6.
K.D. Sharma, appearing on behalf of Respondent 6. It's projected that although there is an endorsement to renew the license, wood-based industry license for the petitioner for 2 years, from 1/10/2021 to 31/9/2023, which has not been given effective. The present petition has been filed under Article 226 of the Constitution of India. If you notice of motion, returnable in 4 weeks. 4 weeks. Requisite extra copies of the petition to South American State and Departmental Council in the course of the day. Next, the pendency of the petition shall not be a bar for the who is the authority?
DFO.
To the DFO. During division within bracket respondent of 5 to renew the license of the petitioner. Pendants, until the next returnable date of the year. Your establishment has been closed.
Yes, my lord.
Your establishment has been closed.
That is the problem, my lord. Finding that problem.
Then make it 2 weeks. 2 weeks. Just a notice, including notice on the prayer for interim relief. 2 weeks. Give a date after 2 weeks, otherwise we will not be listed.
26/6.
Keep your letter.
9.
Here this days notice will go mal here with lengthy petition with number of my lord Supreme Court judgments and orders, my lord.
Just
regarding my lord, personal concern unit my lord, the order was for shifting from the site. But later my lord, Supreme Court distance came, reducing the distance
Where
between the,
Where is your establishment? Where is
Madam?
that?
my lord,
Where is the location of your establishment?
location of
Your establishment?
Kalanchara, my lord. Madhavpur, Madhavdepur Panchayat. One land, it is functioning since license also granted far back in 2019. Then ultimately functioning electricity connection, there were delay, my lord.
Okay.
Location Kalanchara.
RP Sharma, Senior Counsel, Assistant Mr. D. Dole, Counsel for the petitioner. Mr.
You will accept 1, 2, 3, 4, and
I
6.
have 1, 2, 3,
Then it's
4.
Standing Counsel for the Forest Department, appearing for responding numbers.
1, 2,
1,
3, and
2,
4.
3, 4, and 6.
And 6.
6.
And government advocate, my lord. 5.
Mr. C.K. Barra, Government Advocate, appearing for responding number 5. And Mr. A.K. Nath Leonard, CEC, appearing for responding number 7.
Yes.
7, my lord.
I shall notice a motion. Including notice on the prayer for interim relief returnable in 4 weeks. Requisite extra copies of the retention, the served on the state and department constant in course of the day.
Within 3 days, my lord. Within 3
3
days.
days. Yeah, 3 days. Next, the pendency of the retention shall not be a bar for the divisional forest officer from a Karimganj division to examine the grievance of the petitioner and to do the report in accordance with law.
All right.
Next, the petitioner shall produce a certified copy of this order before the respondent of 5 in the order to the notice of the said authority.
Can it be on 19th of July, my lord?
I'm not giving a fixed date. It will be very difficult to manage after the opening.
All right.
Item number 10.
You're there?
Here, madam, matter pertains for non-payment of contractual bill, madam.
Non-payment of contractual bill.
Page 16, madam.
Non-payment of contractual bill as sought for the petitioner. Mr. B. Gogoi, then standing counsel for RMSA. For BTC will be appearing. Mr. P. Nayak, standing counsel for the BTC. Government is there? No.
No, madam.
Okay. Issue notice steps, pendency shall not be a bar for the respondent authorities to examine the claim of the petitioner and to make payment. We found you.
11.
The fact of the petitioner was filed by the respondent number 3 members without giving any notice to the petitioner member. The petitioner member pursues the said that from respondent number 5 member at the register cell deed that is at page number 11.
Where is the notice of selling?
Notice is at page my lord 32 annexure 4 my lord. That is hanged on 4/5/2023 after sealing the
Just-
house. And that is issued to Akash developer respondent number 4 my lord.
I should notice at this stage. For Mr. P.K. Mazumdar in the counsel for the petitioner and Ms. S.
SK, my lord.
Yes,
On
yeah,
behalf of
done it.
S. Pura, my lord.
Done counsel appearing on behalf of Mr. S. Bora, standing counsel for the GMC. That's correct. Agree by the notice. Dated 4/4/2023 under section 3. Pursuant to steps taken under section 337 within bracket 1 and 2 of the GMC Act. Petitioner has approached this court by filing this petition under Article 226 of the Constitution of India. If you notice, including notice the prayer for interim relief, returnable in 4 weeks. Requisite extra copies of the petition be served on the state and departmental counsel in course of the day. But if it is illegal construction, we can't do anything. That part of the house will be demolished. But we can't. Where is the permission? Construction NOC?
Well, that is in the hand of respondent number 4, my lord, who is the builder, my lord, and 5 is the landlord, my lord. I have purchased the set from respondent number 5, my lord.
You can't give you an interim protection if you don't have the GMC permission and you have done it. We can't protect you after 4 weeks.
My lord, in the interim, I may be allowed to take my belongs from the flat, my lord, because that is under lock and key.
Okay.
My lord, in this case, my lord, I may be allowed to call my lord as Bora, my lord, because he is the standing consultant.
You call him
After some.
because we'll permit them to,
Okay.
the authorities will fix a date and time and he will go to
But if he's on lakes, my lord, after some time.
after some time. Okay. But tell him this is the order we are passing. We'll give a date and time and your commissioner will depute someone so to enable him to withdraw his goods from that illegal constructed area, not from the lawful constructed area, from the illegal constructed area.
12,
After some time.
Please, the lordship. The verifications are the registered pharmacist.
Just a moment.
My lord.
Just a moment. You move the authorities for stay because you see, you approach any other authority and we'll grant a stay.
My
That
lord.
is something which is not permissible. There is an appellate provision.
Yes.
You appear before the appellate authority. Now, where is that memo appeal?
No appeal has been filed, my lord, that they have just apprised us by the impending order, my lord, notice is page 296.
Because against any order passed by the authorities,
Lordship is
it will
correct.
lie
There is 36 under surplus 4.
36. No.
That,
Acha,
Pharmacy check.
what is the impugn action?
my lord, the deleted cancelled my license, my lord, registration. Page 296, my lord.
296.
My lord. Two 297 onwards. They issued on 29/4,
Just
my lord. Two 297.
and where is that, what you call, this notice? Cancellation notice, where is that?
My lord, this
Show cause
one,
notice was given. Where is that, this page?
my lord,
Show cause notice was given to you, where is that?
that was not enclosed here, my lord. I have the one copy. Just
Just show it to me.
today I have this.
What is your qualification? Documents of qualification, where is that?
Yeah.
So cause is not a part of the registration. They have not the next paper.
No, it's okay. It's,
Qualification is, my lord,
some mistake here and there.
61.
Just, huh?
matriculation.
No, in this representation, you have started from the license.
Yes,
But where is the qualification? Because you have been, according to this, it says that you don't have the requisite qualification.
my lord.
There was no authentic certificate or experience certificate to substantial eligibility to register as pharmacist.
All these were earlier initially registered before various states under states, West Bengal.
No, that is okay.
Yes, my lord.
After that, you came to this court passed an order.
Yes,
Thereafter, there was a correction of the order.
Yes,
And now they are saying
yes,
that you don't have the requisite certificate or experience certificate.
my lord,
So that is the only issue we are trying to examine.
my lord,
If prima facie you have a, you could make out a case.
my lord. Because the lordship, the honorable court has directed to, before taking any adverse steps, my lord, opportunity of hearing should be provided. That has not been done at all, my lord.
But you have been
Although
given
they
a
have
show cause
issued-
notice, your reply was
Show cause-
considered.
Yes, so cause has been issued. We have replied person to those so
Where is the High Court order that you should be given an opportunity of
Yes,
personal
my lord.
hearing?
In fact, in the act itself also, my lord, if the lordship will take up the act, Pharmacy Act 1948. And also the High Court under 36.
Please read that.
My lord, surplus one, subject to provision of this section, the executive committee may order that the name of a registered pharmacist shall be removed from the register where it is satisfied after giving him a reasonable opportunity of being heard. And after such further inquiry, if any, as it may think fit to make that his name has been entered into the register by error or an account of misrepresentation or suppression of material fact. Now, lordship, then clause number 3, An order under subsection 1 shall be subject to confirmation by the state council and shall not take effect until the expiry of 3 months from the date of such confirmation. Then 4, my lord. A person aggrieved by an order under subsection 1 which has been confirmed by the state council may within 30 days from the communication of to him of such confirmation appeal to the state government, and the order of state government upon such appeal shall be final.
Yes, Mr. Gogoi.
Well, so far as the prayer, Lordship, can you have a look at the prayer made by the petitioner?
Yes,
Page 53 onwards, my lord.
yes.
The first prayer is, my lord, that he should not be, my lord, the impugn order should be cancelled, recalled, or otherwise forbear from giving effect to it. The next part, Lordship will find that page 54. Down, my lord, at the bottom. Why a writ of mandamus should not be issued under respondent to renew the registration of the petitioner, and or why a writ in the nature of certiorari should not be issued, thereby please to quash and set aside the impugn letter that is so and so. And my lord, 56.
Yes,
There, Lordship will see, my lord, here, dated so and so, pharmaceutical, and upon cause or causes being shown, and after hearing the parties be pleased to make the rule absolute, and or be pleased to allow the present petitioners to prefer appeal under section 36(4) of the Pharmacy Act so and so before the government against the impugn letter that is so and so. And he is aware of the provision, my lord, of the alternative remedy. In fact, my lord, similarly situated persons, they have approached, he can take the plea, my lord, that he has not been given the opportunity of hearing.
no, but once an opportunity of hearing is not granted,
No,
it
my lord,
goes to the
that,
root of the matter.
my lord, without annexing that, my lord, so cause notice or in the present
No, that's
petition.
okay, even if that is not there, but you come to page 296 order, doesn't say that you have been given opportunity of hearing.
That instruction I can have, my lord, Lordship may take up in that case, my lord, after, say on Wednesday. Only 1 day's time, my lord.
Okay.
My lord can also, the honorable post order that page 249. Where the honorable
It's okay,
court
once
has
he's getting an instruction, we'll see
Yes, my lord.
on the day,
said, in that case, can it be on 16, my lord?
16th.
My lord.
Okay. Both sides are duly represented. Mr. Ash Sharma and counsel for the petitioner has raised an issue that before cancelling the pharmacy license of the petitioner, an opportunity of hearing as required under section
36(1).
36(1) was not given. Mr. D. Govind, understanding for the health department, submits that he may be permitted to obtain instructions as to whether the petitioner was heard or not. Next para. This on 16/6/2023. So in the meantime, the petitioner shall produce a copy of show cause notices issued to the petitioners to them by way of an affidavit. You take back this.
My lord.
Well, 1 extra copy may be served for the again.
I'll provide it. Till then, not to take any advance date.
Well, that, of course, on that day, Lordship will
It's already
clarify that.
cancelled.
My lord.
Only
They
one
can't do anything more. I'm not issuing a notice. So therefore, interim prayer we can be always be taken up on the next date.
My lord. My lord. How like?
God bless you.
51.
Yes.
But in this case, the order of the assistant register, my lord, is under challenge dated 13th April 23. And the fundamental question, my lord, which has arisen in this case is whether the ARCS had the power to, my lord, adjudicate the election dispute, because it is the election authority under Rule 27. Now, as per instruction, my lord, the power of adjudication is not delegated, my lord, to the ARCS. So therefore, this order is without jurisdiction and it should go to the register, my lord, for fresh adjudication, my lord. And till then, my lord, the departmental officer.
My lord, it is very much provided in the rule itself, my lord. Not to kindly have a look at rule 3, my lord.
Rule 3.
Yeah, come here.
My lord, rule 27 says, my lord, it is
Rule?
my, rule 27 says, my lord, this is the election authority, my lord. And my lord, as per my lord definition, my lord, rule, my lord, 2F, my lord, election authority means register of cooperative societies or any other officer to whom power is of election is are delegated. Now, lordship, kindly have a look 3, my lord, rule 3. It is, my lord, divided. my
Just a moment.
Your lordship will get
Okay.
election rules of.
Election rule, my lord, 2019, my lord.
Notification.
Yes, now which rule?
My lord, from 27 to my lord, rule 2F, my lord, election authority means the register of cooperative society or any officer to whom the power of election are delegated. Now, my lord, delegation, my lord, rule 3, my lord.
No, just a moment. You were reading which provision?
Rule, now, my lord, rule,
No, you were reading which provision?
rule 3, my lord,
Rule 3 of the election rules.
election rules. my lord. It is,
Yes, rule 3.
yes, sir. It is status wise, my lord, divided, my lord, conduct of election to board of director of cooperative society subject to the, my lord, the superintendent's direction and control of the register of cooperative societies Assam. The following officers shall have power to conduct election as per rule, section 41(1) of the act as delegated by the government from time to time. Namely, my lord, register of cooperative society for the state level society, joint register of cooperative society for zonal level societies, deputy register of cooperative society for district level societies, and last, my lord, assistant register of cooperative societies for subdivision level societies. Therefore, my lord, there file the
No,
appeal.
it will be very difficult to accept it. You see, section 41 says superintendent's direction and control of the preparation of electoral rolls and conduct of election. That has got nothing to do with adjudication.
Correct.
Two things are different.
My lord, it is, my lord,
You see, in the what you call Lok Sabha and the state assembly election, all other preliminaries are done by the electoral officer.
yes,
Electoral officer can't take up election dispute and adjudicate.
this, my lord, this overall superintendence is there, my lord. Yes, my lord. Then, my lord, therefore, this, my lord, appeal was filed, my lord, before the register, my lord. Thereafter, my lord, this
Oh,
appeal
really?
was,
We'll give you another opportunity of filing complaint before the appropriate authority.
No,
He
Lord,
can't adjudicate. Once he does not have power, he can't adjudicate.
my lord, therefore, my lord, this register, my lord, relegated the matter to the assistant register, my lord.
Can't. That's why you see, when you were reading section 3 of the rules, I was reading 2A, 2SA. Election authority. Here you see means registrar on whom the superintendent direction and control of the so-and-so and conduct of election of cooperative has been vested under section 1 of 41. So it is only that conduct of elections, but election adjudication that is covered by section
27.
27.
Election dispute, my lord.
27 says, my lord, any dispute relating to election of the cooperative society may be submitted within 3 months from the date of declaration of the result before the election authority. Election authority definition, my lord, page rule 2F, my lord.
Rule 2F.
2F election authority definition, my lord.
Registrar or to powers are delegated.
Delegated.
My temp.
Are
If
delegated.
the delegation is not there,
My lord, the delegation, your lordship will find under section 3, subsection 2. So it has to be delegated by the government. Section 3, subsection 2 of the act.
okay. Yes.
But this appeal was, my lord, forwarded by the, my lord, registrar, my lord, to the assistant registrar. My lord.
It is wrongly, my lord, delegated.
Where is that?
My lord, I have
19.
communicated, my lord, one letter. This is, my lord, letter dated 18 February 2023, my lord. It was, my lord, issued by the additional registrar, my lord, and this appeal along with the High Court's order was, my lord, relegated to the, my lord, assistant registrar. Therefore, he, my lord, passed the order.
Where is that? Give me a copy.
My lord, I am sending to my learned friend. my lord.
No, the delegation should be from the government, my lord. The learned standing council has, my lord, provided the delegation should be from the government, my lord.
No, let me see the document.
It was, my lord, forwarded by letter, my lord, under memo number, my lord, GPSS 12/2020. My lord, 125 dated, my lord, 18 February 2022, my lord. It was, my lord, this appeal was relegated by the additional registrar of cooperative societies to the
You
assistant.
come after some time, give a copy to Mr. Taldur also. We'll take it
Malad.
up after some time.
My lord,
Give a copy, hard
Yes.
copy.
yes.
Give it to Mr. Kadir also.
Yes, my lord. Obliged. 52.
Lord, this is 52 item. Yes, sir. May I please? Lord, this is, Lord, regarding, Lord, demarcation of a particular plot of land. Lord, as per the, Lord, provision of the act, Lord, she has filed, Lord, representation before the circle officer. Lord, she will find at page 31. Page 31 is the, Lord, petition submitted by the petitioner. Then, Lord, no response was given. After that, my lord, she has filed appeal at page 32, Lord, she will find. Page 32. But still, my lord, no action has been taken. Now, since it is, my lord, the declared, my lord, notified service under the provision of the, my lord, act. Now, my lord, in identical issue raised before this honorable court, and this court was pleased to, my lord, dispose of the matter, directing the, my lord, concerned authority to deal with the matter that your lordship will find at page 34. On identical order, we have annexed, my lord. And operative part, my lord, page 39. And my lord, conclusion part, my lord, page 40, para 5.
Mr. M. Mandal, I'm counsel for the petitioner. Mr. C. K. S. Barwar, I'm the government advocate appearing for respondent number.
Phone number was 3, 6.
One also,
Yes, once,
1, 3,
1, 3.
5,
5 and 6.
4, 5 and 6.
Or I think.
Okay, 4, 5 and 6. Okay. You will be appearing for 3,
Was it
4 and
1, 3, 5, 6.
1, 3, 5, 6. And Ms. G. Hazarika, Standing Counsel for the Revenue and Disaster Management Department, appearing for respondent number 2 and 4. The petitioner had approached the you approached before whom?
Initially, my lord, before the circle officer, page 30.
Before the circle officer, Bilasipara Revenue Circle. Where is that page?
Page 31.
Right. Petition dated 20/2/2023 for demarcation of land measuring 1 katha. What is the total land?
Total land, my lord, we have not aggregated, my lord. But we have mentioned
Page 31, huh?
yes.
Land, last page 31. So as demarcation proceedings was not initiated, comma, the petitioner made a representation before the Deputy Commissioner, Dhubri District on 29/4/2023. However, till date, the demarcation process has not been initiated, and therefore this writ petition. This writ has been filed in Article 226 of the Constitution of India. Next one. The learned counsel for the petitioner submits that in a similar situation, this court, by an order dated 19/10/2022, passed in WPC 6657 of 2022, had directed the revenue authorities to conduct land demarcation. Next paragraph. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the petition be served on the state and departmental council in course of the day. Next paragraph. Having noted that as the concerned land revenues personnel are not registering and conducting demarcation cases, the citizens are compelled to approach this court by filing a writ petition to direct the land revenue authorities to perform their duties. Therefore, the court takes notice of unnecessary litigation which is being piling up before this court. Hence, the Commissioner and Secretary to the Government of Assam, Revenue and Disaster Management Department, shall depute an officer to inquire as to why despite petition dated 20/2/2023, the circle officer, Bilasipara Revenue Circle, had not carried out his duty. And a report be submitted before this court on the next date. Next, the pendency of the requisition shall not be a bar for the concerned land revenue staff under the circle officer, Bilasipara Revenue Circle, to complete the demarcation proceedings of the land of the petition.
Lordship, is a notified service under Right to Public Service Act, Lordship. Circle officer is the public servant to do the demarcation process within 1 month, Lordship. After that, he can apply before the deputy commissioner
He has done it.
for appeal, Lordship.
He has done it.
There is also a review authority is also there, Lordship.
That's why you see people are starting coming to court.
Deputy
they will let
commissioner is
them-
the right person to do this, Lordship.
No, let it be commissioner, then his work will be done. So for lesser mortals, nobody cares.
That I agree, Lordship.
Because why you see somebody will apply for demarcation, then rush to court. That means people are fed up with the system. We all know the reputation of Mr. Mandal. He doesn't come here for pro bono. Correct. He has a very good reputation, doesn't come pro bono. So let them, I'm not asking the revenue secretary to do it. He'll ask us, the deputy officer, at least there must be some accountability. Otherwise, there will be no accountability at all.
Diplomats.
Non-performance of the duty. If not passing this order, there is no non-performance of his duty. So
You suspend one person and then everything will be okay. Just do it one and circulate it to your, give a publicity. You see, next time, at least for 6 months, no case will come here.
Lordship.
You see, Mrs. Araika, the problem is otherwise. Not in this solitary case, we are hardly bothered with this. We are not disturbed with this case at all. What is happening is that these litigations are clogging up our system.
That I agree.
So that is why. Let there be an inquiry. If the people are not working.
Diplomats.
53.
Yes.
So after the last occasion, instructed me to find any authorities in the matter. So this honorable court can interfere.
Yes.
Proceeding with the Judgment of Delhi High Court, where an ongoing investigation, Your Lordship, against officials of the Walmart India Private Limited was set aside.
Yes.
Yes. Your Lordship, this matter is against the Central Vigilance Commission instituted by Walmart India Private Limited, challenging the inquiry which has been dealt into by the CVC against Walmart India Private Limited. Your Lordship, while the process of investigation was ongoing, this matter was preferred before the Delhi High Court, where this Honorable Delhi High Court, Your Lordship, had allowed the petition and the inquiry being conducted by the CVC on the basis of the newspaper report was set aside. The Honorable Court stepped into the shoes and decided whether the CVC was entitled to carry out the investigation against WPL, Walmart India Private Limited, based on newspaper reports. That is first leg of my submission. Thereafter, Your Lordship, I'll give another quite a few annexures, in fact. This is an office memorandum, Your Lordship, which was dated 2022, which lays down the entire aspect of the appointment, service conditions, and conditions of repatriation of the chief vigilance officers. If Your Lordship can kindly come to heading H, Your Lordship, which is at page 5. If I may
Yes.
be permitted to read your lordship. Every officer shall revert at the end of his or her tenure and the exact date of completing his or her tenure. He or she will, however, have a choice to revert to his or her cadre on the 31st of May, previous to the date of the end of his or her tenure in case of personal grounds such as so and so. Your lordship would kindly come to the next page, your lordship, at page 6. I'll not be reading the rest of the clauses not relevant to the matter, your lordship. Subclause 2, your lordship. If the officer appointed as CBO has to be repatriated prematurely due to administrative reasons such as inadequate performance and or lack of integrity or such other grounds, such proposal when referred to by the CBC will be submitted for the approval of the competent authority by the establishment officer. Your lordship, this is the crux of the matter which has been agitated before this honorable court. If your lordship can kindly come to page 72, annexure 16, which had been shown to be violated by the respondent number 5. By the respondent number 5, your lordship, as the CBO. Annexure 16, your lordship.
Yes.
Conduct of CBOs functioning in banks and other organizations. Regarding the commission has been receiving references on the functioning of CBOs in the matters of availing perks from organization. The commission would like to emphasize that CBOs functioning in bank and other organizations need to show exemplary conduct in their functioning while availing perks from the organization where they are functioning as CBO. Conduct of the highest standard is imperative on the part of CBOs, as the independence of their functioning and vigilance administration will be adversely affected if they seek favors for themselves from the organization where they are working as CBO. Your lordship would see at annexure 10 at page 54 that the petitioner has preferred a complaint before the Central Vigilance Commission against the respondent number 5 of having violated the provisions of this circular. The attachments are there for the satisfaction of this honorable court. It's a detailed complaint, your lordship, which has been preferred before the Central Vigilance Commission, which indicates the respondent number 5 has overstayed his limitation and boundaries in CBO.
Yes.
For one only.
Ishmael, notice them. For Mr. M. Sharma, then counsel of the petitioner, and Ms. D. Sharma, on it, CC appearing for the respondent number 1. The petitioner claims to be a public spirited person who has lodged a complaint dated 7/7/2022 before the Chief Vigilance Officer from NRL to highlight certain corrupt practices within the organization. The petitioner also claims that the Chief Vigilance Officer has been availing certain facilities and perks to which he is not entitled to. And therefore, the petitioner questions the inaction of the Chief Vigilance Officer in investigating his complaints. Accordingly, we are filing this petition under Article 226 of the Constitution of India. The petitioner is seeking a direction to the concerned authorities to investigate his complaint. And for appointing another Chief Vigilance Officer for NRL. Issue notice, including notice on the prayer for interim. No interim prayer. Prayer for interim review will not be on so. 4 weeks. Requisite extra copies of the petition be served on the CEC for respondent number 1. The petition shall take steps within 2 days for service of notice on the responding members. 4 to 6 by registered postal ID. The council for the petition is appointed to collect the postal receipt number and submit postal card report prior to the executive listing. petitioner is permitted to bring on record any of the additional document he wishes to rely on by filing an affidavit.
The Lordship indulges me for a moment, Your Lordship. The complaints referred before respond number 4. Provided that the complaints referred before respond number 2 and 4 against respond number 5. They bear any petition. They bear any petition against respond number 5. The petitioner has lodged complaints against respond number 5 before respond number 2 and 4 as well. The pendency of that investigation is still pending, Your Lordship. And that is on that context only that I have prayed for an interim protection that the respondent number 5 do not process any complaint referred to him in that period until the complaints against him are disposed of. That lays some credibility issues into the complaints that might be.
Let those things come, then we'll see. Your complaint is against,
Respondent number 5. 5. Respondent number 5. The Chief Vigilance Officer of the NRA. Yes. In fact, there are complaints pending against him before respondent number 2 also. So that might do this.
well, stated about respondent number 5. He's taking talks. Did you add any counsel for the petition also submits that complaint against the CBO
NRA
is also, NRL is also
pending
before the
respondent number 2 and 4.
respondent numbers 2 and 4. Okay. This I'm returning you to.
Yes, sir. The Lordship allows now the permitted to bring it on record by way. I'm grateful. I'm grateful.
Yes, Mr. Dutta.
That's it. I'm coming against tender notice, what you will find at page 44. Start. Sorry, Lord.
This is a settlement of panchayat in your land.
One side. This private land, Lordship, our Patta land.
Mr. U. Dutta, also for the petitioner. And Mr. Your name I forgot again.
P. Handic, my lord.
P. Handic, the counsel for the PNRD department. Appearing for
Hearing for
1 to 6.
1, 2, 4, 5, 6. 6.
1, 2, 4, 5, 6. Number 3, Mr. C.K.S. Barwar, the government advocate, appears for respondent number 3. Next paragraph. By filing an additional affidavit, the petitioner has brought on record a certificate by the government Gaon Pradhan of Goiramari, Goramari, Nagabandha, NAGA, BANDHA, Mahamara, MAH, MARA, Lahori Pam, LAHARI, PAM, Isam. To the effect that Goraimari Sariali daily market was established long back in the land of the 6 persons named therein.
Along with Lordship.
Patta land. Patta land. Full. It is projected that the respondent numbers 6 and 7, I, the executive officer, Lahori Ghat, Anchalik Panchayat, and its president, have issued a NIT, tender notice number capital LAP /458 Bazaar. Next word, Bandobasti BANDA BASTI /2023-24 dated 2/5/2023 for settlement of the said Goraimari Sayari Daily Market. First of in this regard, the Learned Counsel for the petitioner places reliance on the judgment passed by division bench of this court in the case of Rupam Talukdar RUPAM Talukdar TALUK DAR versus State of Assam and others, 2000 within bracket 2009, sorry, 2009 within bracket 4 bracket post GLT 126, which is that settlement of market on a pata line cannot be issued. Next, we issued notice of motion, including notice on the prayer for interim relief, returnable 4 weeks. Requisite extra copies of the petition be served on the land. State and departmental council in course of the day. Next, the petitioner shall take steps for service of notice and respondent. Within 2 days for service of notice and respondent. 7 by registered post to the next balance. In the next returnable date, the respondent numbers 6 and 7 are restrained from proceeding with the settlement of the with the finalization of the
There's a small submission that I would like to make.
instance.
First of all, we need to ascertain like whether this is a private market which has been established on his private land or not. Let there be an independent survey by the DC. Let him submit a report because
Till then, don't proceed.
Gaon Pradhan has given this certificate, my lord. Let there be an independent survey on this aspect. Till then, let the market be run by the department.
You don't have faith on this government, Gaon Buda.
Lord, I have faith in my DC. He will be an independent, impartial authority.
Then stop this, what do you call, these persons, why should be they be there? The government has no faith on them.
Or by the circle officer under the aegis of the
We'll
DC.
permit you to make an inquiry, but till then, don't proceed. Till the next return of date, don't proceed.
Can the department run the market?
No. Why in his pata land you will run a market? Restraint from managing the tender number so and so is the next date of the returnable date. First, it is also clarified that the pendency of the retribution shall not be a bar for the deputy commissioner, which Morigaon to cause an inquiry through his subordinate staff as to whether the market referred above is operating in the private pata land of the petitioners. First, it is also clarified that this order shall not be a bar for the Laurigat Anchalik Panchayat to settle any market which is not being operated in the pata land of the petitioners. Just give this description. Petitions.
Your lordship concern only serial number 19.
Which one?
Serial number 19.
Which page?
In vernacular, it is page 48. Sometimes with it is page 45.
19.
19. Gorimari Sadiari doing it.
Only in respect of Gorimari, Sariali, Dainik Bazaar,
Dainik Bazaar.
without affecting any other market shop to be settled by the said notice. You just write within bracket, serial number 19. Goramari, Sariali, Dainik Bazaar, within bracket, serial number 19 of the tender notice. We've given you liberty. If the land is not this pata land, then you can proceed. If it is a pata land, it will be restrained till the next returnable date. The petitioner shall produce a certificate copy of this order before the respondent numbers 6 and 7, giving the order to the notice of the said authorities.
Not a copy of the order may be given so that we can give it to the.
The standing counsel for the PNRD is permitted to transmit a downloaded copy of this order to the authorities. Yes. You get, if you want to just tell the court master, get a downloaded copy also.
May I please your lordship? Lordship, the petitioner liability established in the year 1965, lordship. And lordship will find some documents, lordship, at page 21, lordship. Lordship will kindly have a look at page 21. Then in 2004, lordship, the certificate of possession.
Issue a notice at this stage.
Lordship.
Perhaps this
And-
matters pertain to Assam Board of Revenue, Lordship, because right here only Deputy Commissioner have given some allotment to that Tiva committee. So that order can be challenged before the Assam Board of Revenue under section 69 of the Assam Land Revenue Regulation. That's all.
Settlement has been given,
Allotment.
allotment.
Lordship will find that page
Page
49, lordship.
para number 11, Lordship. Para number 11 of the petition. Page number 13.
Land revenue regulation. Land revenue regulation.
Section 169. Subsequent to settlement certificate. Accept. Certificate.
No, this will not apply.
Sir,
This will not apply. This chapter 9, this is you are referring to section 1, regulation 169, right?
Lordship, yes.
169 is applicable only for chapter 10. Chapter 10 is protection under protection of backward classes. I think a property authority would be someone else. Just find out if there is an appeal, there should be something else. Ask someone to
Lordship.
take it up at 2 o'clock. Ask someone.
Yes, boss.
Because, you're right, there may be a provision for appeal.
Yes, in other chapters.
162 would not be appropriate.
And since 19,
There is a provision of appeal, in fact, in under 1971 letter also, Lordship.
I don't know, just find out the provision because
Can I take about two, Lordship? Let me-
at 2 o'clock, find out at 2 o'clock.
at 2 o'clock. All right, Lord.
Yes, sir.
Made the Lordship.
Yes.
It's a peculiar case, my lord, for filing an application to alter the case of date of hearing, my lord. Sort of punishment was given, cost was imposed, and without hearing in depth the merits of the case, interim order was passed, no personalized. I take your lordship straight to the application, page 63 to 64. Annex 4.
364.
Page 63 and 64. Annex 4. Application as per provision of Act rules praying for alteration, modification, etc. of the order dated so and so, including the date fixed for final hearing in the aforesaid case number so and so. Assam Administrative Tribunal. Next page. Paragraph 4. That was the main prayer. That the next date of paragraph 4 is 64. That the next date of hearing has been fixed on 24/5/2023 by this honorable tribunal, which may be altered to another suitable date in the mid part of the next month, in view of personal difficulties as well as inconvenience of the council on the date fixed in the instant matter. So, my lord,
This is by whom?
this is by the Guwahati University.
Okay.
Guwahati University is the respondent number 1, 2, and 3 in that appeal case filed by the respondent number 1.
Yes.
Now the impugn order, Annex 5, page 65. Mary,
Yes. Yes.
24/5/2023. Uday Kumar Khonikar versus Guwahati University. So-and-so learned advocate for the appellant is present. Learned advocate for respondent number 4 is also present. Both of them are found to be ready for hearing of the appeal. Sri so-and-so, learned advocate who has stated to be junior of Sri so-and-so, learned advocate representing respondent number 1, 2, and 3, the Guwahati University Authority, has raised an application dated 19/5/2023, stating that on the last date fixed for hearing, that is on 27/4/2023, the engaged advocates for respondent number 1, 2, and 3 were busy in the Honorable Guwahati High Court in the hearing of several sensitive cases for which the council concerned could not reach the Honorable Tribunal on time. It is also stated in the petition that although the next date for hearing is fixed today, that is on 24/5/2023, it is required to be altered to another suitable date in view of next business. Personal difficulties as well as inconvenience of the council today. The reason seeking alteration of the date to another date appears to be not convincing in the opinion of this tribunal.
Heard on the application as well as the arguments and counter arguments made by each of the parties, the learned advocate for the appellant has strongly objected to the application submitted by respondent number 1, 2, and 3 for alteration of the date of hearing, contending that on the respective dates fixed for hearing of this appeal, they were fully prepared for placing the argument before this tribunal. Moreover, the engaged advocate representing respondent number 4, that is NIT Arunachal Pradesh, has to incur a huge expenditure in attending before this tribunal to participate in the hearing. From the submissions made by the respective advocates for the appellant and respondent number 4, it appears that due to adjournment, they have been deprived of the hearing of the case on the fixed date due to no fault of them, and they have submitted that in the event of adjournment of the case today, a cost may be ordered to be paid to them by the respondent numbers 1, 2, and 3, as may be admissible. The learned advocate for respondent number 4 has also submitted to provide next statement. Necessary cost to respondent number 4 as well, as may be admissible. After consideration of their respective submissions, the tribunal is of the opinion that it is justified to provide them with necessary costs for adjournment of the case today. As in the earlier date, also the learned advocate for respondent number 1, 2, and 3 was found absent without any intimation to this tribunal. Estimation of cost as submitted by the appellant and respondent number 4 has been taken into consideration by us. In view of the above, it is important. This tribunal orders that 1. The prayer of the respondent number 1, 2, and 3 for adjournment of hearing is allowed, fixing 13/06/2023 as the next date for hearing of the appeal on adjournment of the same today, and no further adjournment shall be permitted on the next date under any circumstances whatsoever. 2. In the meanwhile, the authorities of the respondent number 1, 2, and 3 shall not initiate any coercive action against the appellant affecting his service in the NIT, next page, Arunachal Pradesh, as well as under the Guwahati University till this appeal is finally disposed of by this tribunal. And 3. A cost of ₹5,000 only shall be paid by the respondent number 1, 2, and 3 to the appellant in respect of today's cost of the case, and a lump sum amount of ₹24,000 only shall be paid to the respondent number 4 by respondent number 1, 2, and 3 as today's cost, as it is submitted by the concerned advocate that he has been conducting the case before this tribunal, traveling from Itanagar to Guwahati, which involves several expenditures apart from traveling expenses. Respondent numbers 1, 2, and 3 shall deposit the amount of cost as stated herein above in the registry of this tribunal through demand draft drawn in favor of appellant and respondent number 4, as the case may be, before the next date of hearing. Respective parties shall, next is note, draw their drafts from registry after due acknowledgement of the same, serve copies of this order to the appellant and respondent respectively for necessary compliance. Now, my lord, kindly turn, I'll be very short, my lord, paragraph 9, my lord. Kindly turn to paragraph 9, page 30. Paragraph 9, my lord, page 30.
Yes.
That the petitioners humbly beg to state that on 24/5/23, the learned tribunal has taken up the aforementioned application dated 19/5/23, that adjournment application, my lord, for praying for alteration. And while fixing 13/06/2023 as the next date for hearing of the appeal, surprisingly, without allowing the said two advocates representing the respondent Guwahati University authorities an opportunity of hearing in that case, in spite of their repeated insistences for that, as well as elaborate explanations regarding personal difficulties as well as inconvenience of the council on that the date fixed, that is on 24/5/23, directed inter alia not to initiate any coercive action against the appellant, with further direction to deposit an amount of ₹5,000 mean for the appellant and ₹24,000 as a lump sum amount mean for the respondent number 4 in respect of that day's cost before the next date of hearing by the respondent Guwahati University authorities in the registry of the learned tribunal. It is humbly stated by the petitioners that it is totally perplexing how an order could be passed for not to initiate any coercive action against the appellant without hearing the appeal case at all. and how the learned tribunal's earlier order dated 27/4/2023 for giving a last chance in the event of absence to be heard in their absence and decided accordingly could be flouted and ignored by the said learned tribunal itself, taking an U-turn and a self-contradictory stand. Further, there has also been the critical aspect of the engaged counsel for respondent number 4 on that particular day, instead of the other regularly engaged Guwahati-based counsel concerned. It is humbly stated by the petitioners that on 24/5/23, entire focus was on the aspect of imposition of cost rather than hearing of the appeal, as per the learned tribunal's earlier order dated 27/4/2023. Though the counsels of the respondent Guwahati University authorities repeatedly insisted for hearing of the appeal case, which was not even reflected in the said interim order dated 24/5/2023 and also not denied in the said interim order. Now, my lord, we can skip paragraph 10, paragraph 11. Page 16.
Show me, where is this order of 27/4/23? Where is that?
My lord, annexure 3,
Page
page 62.
52.
62, my lord. Just before this annexure 4. May I read, my lord, 62. It is dated 27/4/2023, page 62. May I read, my lord? Sri so-and-so learned advocate for the appellant and Sri so-and-so learned advocate representing respondent number 4, that is NIT Arunachal Pradesh, are present, who were found ready for the hearing. However, nobody is found to be present before this tribunal to represent respondent number 1, 2, and 3, and no intimation whatsoever found to have been sent to this tribunal, stating the grounds of absence of the advocates for respondent number 1, 2, and 3. This tribunal expresses its anguish over the absence of the advocates representing respondent number 1, 2, and 3 without any intimation, while the appeal has been fixed today for final hearing. Although the advocates representing the appellant and the respondent number 4 are ready for hearing, this tribunal considers it appropriate not to take the hearing in absence of respondent number 1, 2, and 3, who are the principal respondents to present the case of the respondent Guwahati University, its registrar, and the executive council. Hence, in the interest of justice and fair play, the case is adjourned today, fixing another date of hearing so as to give a last chance to the respondent number 1, 2, and 3. It is clarified in this connection. It is important, my lord. It is clarified in this connection that in the event of absence of respondent number 1, 2, and 3 on the next date fixed, the case will be heard in their absence and decided accordingly. It will be heard in their absence and decided accordingly. My lord, the next page, 2 pages, clarifies the entire, my lord, background, my lord. Affidavits have been exchanged, my lord, and my lord, other aspects, my lord. And now, my lord, the last
Yes.
paragraph 11, my lord. Page 16, my lord. Paragraph 11. Married. That the petitioner respectfully beg to state that on 24/5/2023, the learned tribunal could have either proceeded with the hearing of the appeal case as per its earlier order dated 27/4/2023, or could have only refixed the date of hearing to a convenient date on the basis of the aforementioned application dated 19/5/23, without any order regarding coercive action and or cost, in tune with the laws of the land, including the relevant provisions of the Assam Administrative Tribunal Act 1977 and the regulations thereunder. Further, there is no question of affording, next page, my lord, affording a last chance in learned Assam Administrative Tribunal's earlier impugn order dated 27/4/2023, since it was the first day of hearing in which the council concerned could not reach in time due to some unavoidable circumstances, as explained in the aforesaid application dated 19/5/2023. Particularly, it is most surprising that when all the parties, including the councils of respondent Guwahati University authorities, were ready for hearing of the appeal case on 25/4/23, only the application dated 19/5/23 was taken up for disposal, though it was duly filed before the Acts registry 5 days back, and that no hearing of the appeal case, at least regarding the maintainability, admissibility aspect, as per its earlier order dated 27/4/23, took place at all on that day. Most importantly, The impugned order dated 24/5/23 has not mentioned anywhere in the entire long order, and there has not been any whisper that the counsels for the respondent Guwahati University authorities were not ready for the hearing of the appeal case that day. In fact, they repeatedly prayed for hearing of the appeal case as they were well prepared for the same, but that was denied straight away, and they were not given the said opportunity for hearing on that particular day, to their utter surprise and astonishment. Lord, section 9(1)(b).
But you see, Mr. Fukan, you see, if on 24th you were ready, you could have just not pressed that adjournment petition and you could have heard. Because you see, your adjournment petition is on board. So your readiness and willingness to argue the matter can't be presumed.
Lord,
On 19/5, you gave a adjournment petition,
Miller,
correct?
Miller.
Was it served to others? Advance copies were served to others.
Since 5 days back, Miller, it has been submitted to the
No,
registry of
it's
the.
okay. Somebody is filing an adjournment petition here, I understand. But was copies served to the other side? So that they will not be prepared for hearing.
Lord, normally copies have been served to the registry.
You see, if any registration, if any petitions are filed in the trial courts, including Board of Revenue,
No.
the registry of the court does not transmit it to the other side. That is one. Second is that on that date, 24th, it is not your case that you did not, you had stated that you are not pressing that adjournment petition. So once an adjournment petition is there, so what happens today? If an affidavit or adjournment has come to the court, today the matter is for hearing.
Miller.
Somebody files an affidavit in the registry of this court, which has come to the record, saying that party X is praying for an adjournment.
The
Now, what should
vital aspect is the before 5 days from the date fixed, Miller, the application has been filed.
No,
So
that is
they
okay.
should have taken up the matter, taken up the application prior to the date fixed, Miller. On
Can't take up. It cannot be taken up. You see, you see a situation where on an off date, somebody comes, files a petition before any court, and then the matters are adjourned, or any other orders are passed. You see, this order of adjournment is also a judicial order. I can't permit the municipal magistrates to start passing orders on an off date.
Miller, the basic thrust of the earlier order on 27/4/2023 was that in your absence, it will be heard expertly. So Miller, without refixing the date, altering the date fixed, Miller, they should have proceeded with the hearing since the advocates concerned are.
Mr. Pugat, this is something I do daily. In every matter, you just point me a matter in the cause list. I'll give you the file, and you will find that we give 4 weeks time to the respondent to file an affidavit. He doesn't file. Then we say last chance. Then also no affidavits are filed. Then we give them one more chance. But this is something we are doing regularly. We don't keep our word. Looking at the convenience of the lawyers, we give them, the state will come with an explanation that the officer is on election duty. Please fix it after 2 weeks. And we are doing it despite last chance, twice or three last chance. We are still doing it. So if I take a stand that it was wrong on part of the court below, or the Assam Board of Revenue, to have given one more opportunity, would mean that I'll have to follow it first. I must set an example. First, I must mold myself to see that when I take up a matter in the board, then I don't give an opportunity to the other side. I close it and I start hearing. If I can't do it, will I expect the Any other court to do it?
Milord, there may be sometimes, Milord, it happens, Milord, some inconvenience, some personal difficulty, only for the first day. It was not giving the last chance, Milord. For the first day, hearing was fixed, the date was the first day. The advocate concerned could not present due to some inconvenience, Milord.
It's
Those
okay.
have been reflected, Milord. Milord, he could not reach on time since some sensitive cases were here in the.
It's okay. It's
So,
okay.
Milord, he explained everything, Milord. So, Milord, there is no question of giving a last chance. That was the first day. All affidavits were exchanged, Milord, clarifying the stand of the Guwahati University. And basically, it was regarding maintainability, admissibility of that petition. Since the appellant should have filed an appeal petition before the chancellor under section 35 of the Guwahati University Act. That was not done. So that maintainability, admissibility aspect is writ largely. On that aspect, the hearing should have been proceeded, Milord. And since on 27/4, the tribunal itself stated that in his absence, it will be, Milord, proceeded ex parte. So hearing should have been, Milord, proceeded ex parte, Milord.
No, I could have appreciated if you had.
And there is no whisper, Milord, nothing, no reflection, Milord, that the advocates concerned of Guwahati University were not ready that day. Innumerable, Milord, WhatsApp messages and other, Milord, email messages have been, Milord, exchanged, Milord, 2-3 days back, Milord,
With whom?
with the advocates concerned, Milord, of Guwahati University. So, Milord, I have stated in my paragraph, Milord, paragraph number 8, 9, 10, 11 onwards, Milord.
No, but don't you feel that your stand is what do you call it, inconsolable? Because you see, what is happening is that your adjournment petition is on board. How can I can take a cognizance that you are ready for hearing? Because if I am ready for hearing, I'll say that, well, I am not pressing this adjournment petition, I am ready. End of the matter. In the trial court, we just have to write, not pressed. End of the matter, we start hearing. But when an adjournment petition has not been withdrawn, supposing the court proceeded with the hearing, then you would have taken a plea that, well, my adjournment petition was there and it was not disposed of, that was not, no order was passed.
Milord, the court, the tribunal has not allowed to withdraw the petition, Milord, has not allowed to proceed with the hearing, Milord. So, Milord, that aspect has not been reflected in the order sheet itself, Milord. Otherwise, the order sheet itself would have reflected. The counsels concerned are not ready for hearing and they are not withdrawing the petition. So, Milord, and
Just
one aspect is cost.
just a minute. Because if somebody travels from long and imposes a cost.
On that particular day, Milord. Otherwise, Milord, a Guwahati-based advocate has been, Milord, conducting the case for last 1.5 PM. And he is just a formal party, Milord, supporting the cause of the appellant. I have stated in my other paragraphs, Milord. It will take some time, that is why, Milord, I have been very big. All along, Milord, to Guwahati-based advocates, Milord. In the order sheet, it has been reflected. Kindly see page 61, down below.
It's okay, but on that day, somebody was there from outstation.
On that particular day.
On that particular day, he asked for cost.
So he
He asked for
said
cost.
he submitted that he is from Arunachal Pradesh, so cost has been imposed. The first day, counsel concerned could not reach in time. Reasons have been explained. In spite of that, cost has been imposed. Their own order, Milord, that in their absence, Milord.
It's okay, but an adjournment petition has come. The order, you see the order, it is clarified that in the event of absence, then only ex parte hearing. Here you see in the order, page 62, it is very clear. It is clarified that in connection with the event of absence of the respondent 1, 2, and 3 on the next date. The case will be heard in their absence. Now, on that day, you are not absent.
Milord.
You were present and there is an adjournment petition. then the court could not have proceeded. This order doesn't say that even if the other side files an adjournment petition, then also will proceed with the hearing.
One vital aspect, my lord, that application has been submitted 5 days prior to the date fixed. my
No,
lord.
that is okay, but you
So
see,
they should have taken up that petition prior to that, my lord.
no.
Same day they have taken up the
Mr.
petition.
Fugan,
my lord.
you see, how will you like it that you will be waiting in the court
My lord.
for the entire day? At 4:15, just before I rise, your matter is not called. And then when you ask why my matter is not called, the court master will give a reply that it has been adjourned in the 10:30. Now here what has happened, there's an adjournment petition filed 5 days in advance. The other side does not know that there is an adjournment petition, and therefore the lawyer travels from far away place and attends the proceedings here. Now, where is he at fault? And if the court awards a cost, how it will be so bad that the court under 226 should interfere?
My lord, the tribunal did not have imposed cost, at least for absence of 1 day, my lord. And that was also explained, my lord.
No, we don't know how the court reacts.
And that last chance aspect, my lord. No chance was given, my lord. That was a day was fixed in the last week of April on 27/4. That day the council concerned could not be present. Everything was explained. So giving a last chance, my lord. At the drop of the hat, my lord, this, my lord, imposition of cost as well as, my lord, no coercive action without going through the merits of the case, my lord. All along those Guwahati-based advocates, page 62, 61 is clear, my lord. Page 61. Guwahati-based advocates have been conducting, my lord. All of a sudden, one advocate
No, you
comes.
see,
from the-
Mr. Fukan, I don't find fault with it. You see, the same thing is happening here in your case. You are the person holding the brief. So in your absence, when your chamber mates are there in the court, and taking steps. Say, for example, if, in the motion day, a senior comes, moves the matter and goes away. For all other stages, admission, orders, all throughout, the chamber colleagues of the senior is taking steps. Now, at the time of hearing, then the senior doesn't come for some reason. Can I say that all throughout your chambermates were taking steps and therefore today I'm not granting adjournment on your account? That the lawyer who was conducting the matter all throughout will start hearing him. I take a rest and come back. I'll just take a 5-minute break. Because Mr. Fukan, I'm not very satisfied.
My lord, I'll try to satisfy the law.
Yeah.
My lord, I beg to draw your lordship attention to page 60, my lord. The order passed in the month of March, my lord. 28 March 23, my lord. Page 60. Page 60, 60,
60.
annex R.
Yes.
It is dated 28/3/23. Earlier order. Last earlier order. Learned advocate for the appellant so and so is present. Learned advocate for respondent number 4 is also present. Learned advocate representing respondent number 1, 2, and 3 is present and filed additional affidavit, copy of which has been served on the appellant. 6/27/4/23 for final hearing. Thereafter, my lord, that 27/4/23 order has been passed, my lord. But prior to that, my lord, page 61.
Just a moment. Because this Board of Revenue does not have a power for a review.
Assam Administrative Tribunal. Section 9(1)(b) review power. Assam Administrative Tribunal Act 1970.
Administrative Tribunal Act. Should we do that?
Section 9(1)(b). It should be read with Regulation 3(2). Assam General Clauses Act will be applicable. And Section 23 of Assam General Clauses Act, you have power to vary, amend Section 9(1)(b).
Then I close it with by granting liberty to you to move the tribunal for review.
My lord, that application, my lord. That application, my lord, alteration, modification, as well as review of the earlier order dated 27th.
You move the tribunal. We give you liberty with close the repetition with giving liberty to exercise this power of review. Heard. Mr. P.J. Fukan, counsel for the petitioner. Next paragraph. The case projected by the petitioner is that in the proceedings of case number 1 ATA/2022, the pleadings were exchanged only on 28/3/2023. And by the order passed on the said date, comma, the case was fixed on 27/4/2023 for final hearing. Full stop. On 27/4/2023, comma, the learned counsel for the petitioner could not attend the hearing. And the date of hearing was adjourned to 24/5/2023. First of all, it is projected that on 24/5/2023, comma, as the counsel holding the brief for the petitioner has some difficulties to attend the hearing, and therefore on 19/5/2023, a prayer for adjournment was submitted before the Assam Board of Revenue. So sorry, Assam Administrative and Pension Tribunal. Full stop. On 24/5/2023, comma, the learned Assam Administrative and Pension Tribunal, comma, while granting adjournment, comma, imposed a cost on the petitioner to the extent of ₹5,000 to be paid to respondent number
One.
respondent by here, one, and a sum of rupees 24,000 on the respondent number two.
In the instant meter, respondent number two.
Huh?
Respondent-
I'm definitely here on the respondent to in this petition. First off. Accordingly, comma, next, accordingly, comma, to challenge the aforesaid order. The present petition is in filed under Article 226 of the Constitution of India. First off. The court finds that under the provisions of Section 9 within bracket 1 within bracket small b of the Assam Administrative Tribunal Act, 1977, the Assam Administrative and Pension Tribunal has the power and jurisdiction to review its own decision or order in any case. First, next, therefore, comma. Instead of keeping the matter pending before this court, comma, the court deems it fit and proper to delegate the petitioner to approach the learned Assam Administrative and Pension Tribunal party with an appropriate application for review under Section 9(1)(b) of the Assam Administrative Tribunal Act, 1977. Sorry, I have to get his submission with that. It is also submitted that when the issue of maintainability of the petition was also a question to be decided on merit, comma, without giving an opportunity of hearing to the petitioner, comma, an interim order Where is that interim order?
My lord, last page, last but one page. Page 67, my lord. It starts from page 65. Page 67 is the relevant order. Para 2, no coercive action.
Put my past interim order to provide that the petitioners, the petitioners, who are the petitioners here? All this 1, 2, and 3.
1, 2, and 3.
The petitioners herein, who are the respondent in these proceedings of
Appeal
case number 180A 2022. To restrain from taking any coercive action against the respondent number 1 herein, affecting his service in the NIT, Arunachal Pradesh, as well as under the Guwahati University, till the appeal is finally disposed of. Now all the rest of them will become accordingly, as it is still within the domain of the Assam Administrative and Pension Tribunal to review its order, the court is inclined to close this petition with liberty to the petitioners to move the Assam Administrative Tribunal Pension Tribunal. The Assam Administrative and Pension Tribunal for a review of this order dated 24/5/2023. First off, needless to mention that if such an application is filed, the Assam Administrative and Pension Tribunal shall pass an appropriate orders in accordance with law.
Tomorrow is the next date fixed for hearing. Prior to that, we will have to, that cost aspect, so,
You can always pay for an exemption of cost. Along with the prayer for exemption of cost.
till then, this order, stay of that order,
No, not required, you can move it. Since you're not entertaining, otherwise I go and wear it and then I have to. My mind which I am formulating is that it might be adverse to you. Since your personal interest is also involved, I've seen that. I'm not passing any adverse orders.
Most obliged.
Get your book, I'm returning it.
Obliged.
The matter pertains to the stuffing of the machine board service of the petitioners park hardware. The lawful will find at page number 32, whereby the petitioner was settled with the hardware. Annexure 3, page number 30.
Where is the immune order?
Between order, your lawful will find at page number 36,
36. Where is your settlement order?
Page number 32.
Yes, now where is the representation?
I got page number 37.
37.
Very good. Just 37. Page 37. Respectful submission is that we have been running Rangeshwari from Jaljali Devshila Ghat since last 45 years, 50 years. After taking its settlement from Samaria Development Block by submitting tender. This year also we took settlement from 1/7/2022 to 30/06/2023. The dividend of this ghat is distributed to 7 temple of mosque for the development of religious institutions. But sadly to say that on the basis of an application submitted by Requisitioned Islam, the lease of Dokosi Bhokuradia Rangeshwari Pijupara Ghat, the aforesaid ghat has been temporarily closed by letter number so dated 27/3/2023 on the pretext that said ghat falls within 3.2 kilometers. But if measured from the place where where Rafiqul Islam is running his ghat, it would be beyond 3.2 kilometer distance. But on the pretext that Rangeshwari appears in the name of the ghat, distance is measured from Rangeshwari only.
Now, my lord, the impugned order, the measurement.
Yeah,
has-
let him complete.
Yes. Therefore, sir, madam, you are highly requested to be kind enough to restore the aforesaid ghat and gratify us. This is the humble prayer of the public before you. So, well, I have been running the ghat, my lord, in respect of which place it was settled, my lord. This is clearly stated in the settlement order itself, my lord. I have not shifted my place, my lord. If that, my lord, the ghat falls within the 3.2 kilometer radius, my lord, then they ought not have settled the ghat to the petitioner, my lord. Firstly, and secondly, that, my lord, if the distance is calculated from the actual place where private respondent number 7 is running his ghat, then the question of distance would not come, my lord. But that the name of the ghat of the respondent number 7 has also got the name, my lord, Rangeshwari. The distance was calculated from Rangeshwari only. And if it is calculated from Dokosi, my lord, it would be beyond 3.2 kilometers. But calculation was done from Rangeshwari only. So
But
since
this page 37 you are showing me
Yeah.
is not your representation. It's by
No.
someone else.
it is a public, general public.
So you are not aggrieved. Public complaint is there, but I don't find you to be a aggrieved person. Does it doesn't make an objection? But yes, what you are saying, Mr.
My lord, the concept of free play in the joints, the administration, both the PNRD department as well as the inland water department, they have jointly measured the distance and it is coming within a radius of 3.2 kilometers, my lord. Second paragraph of the impugned order,
Which page?
page 36, second paragraph. In connection with above, the distance from DBRP, Dakuchi, Akuradia, Rangeshwari, Pijupura, which is the ghat which belong to respondent number 7, that is Rafiqul Islam. So from his ghat to the petitioner's ghat, that is Rangeshwari Pam Jaliala Parghat, the distance, his ghat is falling within the radius of 3.2 kilometers. And this
practice was jointly undertaken by both PNRD as well as the Indian Water Department. And it was found since it's coming within the radius of 3.2 kilometers, his ghat should be closed. And I have the copy of the rule also. This has been done under the rules, which is the Control and Management of Ferries Rules 1968, the Government of Assam. I have a copy of the rules. Rule number 35. This has been done under the rules. It's not a discretionary or a arbitrary decision that has been taken. Rule 35, my lord. Recognized non-transport ferry oblique ferries only can run within the distance of 3.2 kilometer on either side of the ferry. The lessee shall have no claim for compensation or refund of kist money on that account. So he won't be able to take the benefit of Rule 49 of the Assam Panchayat financial rules as well as in this case.
Will that not be illegal? You know, you are the owner. You know it is 3.2. You float a tender, take money from him, and then say it is within 3.2 and therefore stop. Can you do it? Can the state do that?
The state has, as far as his petition goes, my lords, it is now being run by that respondent number 7.
So we'll ask these people.
We'll take some.
No, we'll ask these people to pay compensation, damages. Public law remedy applies.
Under Rule 449, my lord, yeah, you can give.
Not 49. I'll invoke the 226 jurisdiction. It is a public law remedy. The state government with eyes open, allot them ferry service, which is within 3.2. Correct. Previously, you don't do that exercise. You give it to him. And then you take away that right and say that he has got no right to say to seek compensation. You're not giving him compensation. We'll invoke public law remedy, give him damages.
Proportionate damages may be.
Not proportionate. We'll give him 5 lakh rupees. Why proportionate? The court is not bound by any rules of procedure. So why I should not invoke? I'll put this question, let the department reply, and then we'll impose cost. I'm not doing it today ex parte, but I'll impose by giving you a reasonable opportunity to argue. Mr. K. Adil and counsel for the petitioner. Also heard.
I am for 1 and 2, madam.
Ms. M.D. Bora, then standing counsel for IWT, representing respondent numbers 1 and 2. Mr. For government will be there. Mr. C.K.S. Barwal and government advocate appearing for respondent number 3. And Mr. Handy, standing counsel for respondent numbers
4 and 5.
For the standing counsel for PNRD department representing respondent numbers 4 and 5. Next paragraph. The petitioner claims that he was after a tender process, the petitioner was settled with with
there's a small issue.
Rangesh.
A small issue, the fact
Yes.
that I would like to bring your
Yes,
mind
yes,
to this. But it should, this is a scenario that I'm like, this is a question that I'm putting to myself. At that relevant period of time, my lord, the R7 was not maybe allotted the ghat by the Inland Water Department at that relevant period of time. So this particular complaint has gone from the respondent number 7 to the authorities, stating that the petitioner's ghat is within a distance of 3.2 kilometers from his ghat. So this is not a suo motu exercise that has been undertaken by the.
No, you see,
by the
I can
department.
understand, being a student of law, I will understand that there was a flood and one part of the land was taken away by the river. And so therefore, if say Dag number 1 has 10 bigger land, only 2 bigger remains. I can understand that. But is it your case that because of certain events, the length of the what you call, there was a natural realignment of the distance of the ghat? Is it your case?
Lord, my case is like right now, as with the limited information that I have, I am yet to ascertain whether R7 Rafiqul Islam was given or allotted the ghat.
I'm
or he was-
absolutely not interested in the spot number 7. He is a mere appendix.
He has filed the complaint.
It's okay. He's a mere appendix so far as I am concerned. Appendix, you understand, is said to be the worthless part in the human body.
It will be.
Although it must have some significance, but God doesn't make anything unnecessary.
No,
It
gives
must have some
appendicitis.
significance. Correct. Now, the question I'm putting it to you is, not to you, it's to the state. I'm not putting question to Mr. Handig. I'm putting to you the question to the state. Now, is it a case that when the settlement took place, the distance was 3.2 kilometers? And after that, after something happened, say like earthquake, it has moved the boundary from 3.2 to 2.7.
I know the banks may have diverted because of a
Correct.
situation like flood. May it's
Correct.
possible. Act of
And
God.
no one in the state knows about it. If a bank shifts half a kilometer, you think it will not be a news?
Or we'll have to seek instructions if there is
Correct.
such news.
Correct. Because if that be, I read all the worthless news I read in the newspapers. So at least I'll not miss it. Good news I may not read, but this news of this nature I'll definitely read.
Highly
It will not miss me. And even if I miss it, the evening news channels will not let me forget it. Huh?
Yes, ma'am.
Group discussion, it will not allow me to forget it. Was settled with Rangeshwari Pam, Rangeshwaripam, Joljali, Jaljali, Diosida, Deosila, Ghat. With settlement order number
CHAP.
is page 32, huh? CHAP so and so, dated 36/2022. Full stop. Thereafter, so the settlement was for a period of 1 year. From when to when?
1/7/2022 to 30.
1/7/2022 to 36/2023. First time. It is projected that prior to the completion of the tenure of the settlement, by virtue of the impugn order number so and so, page 36, dated 27/3/2023, the executive officer and ex officio secretary, Chamaria Anchalik Panchayat, who was the settling authority, had
Temporarily.
directed the petitioner to stop the boat service at his settled ghat till further orders from the said authority, on the ground that that on joint measurement of the two of the distance of Dakuchi, Dakuchi, Bhakuradia, Bhakuradia, Rangeshwari, Rangeshwari. Pijupara, Pijupara. TO2, Rangeshwari Palm, Jaljali, Dolsila Parghat. By the IWT department and Samaria Anchalik Panchayat, the distance was found below 3.2 kilometers. First off, accordingly challenging this at impugn order dated 27/3/2023, the present requisition has been filed under Article 226 of the Constitution of India. Next, at the outset, the learned standing counsel for the PNRD department has referred to Rule 33,
35.
35 of the Control and Management of Ferries Rules, 1968. Oh no, this is 76 rules.
My lord.
You're referring to rules.
Rule 68 rules, my lord. Control and management of ferries, rules 1968, rule 35.
Or 33, rule 33 of the said
That must be the old act.
rules. Huh?
That must be the old rules. The new rules are 1968 rules. I have a copy of it.
1968 is 33.
35, my lord.
It doesn't have 35.
Yeah, so it's page 11 now.
Page 11. Oh,
That's
acha.
all.
I sorry, I mixed up. Yes, 35.
Page 11, I think, no?
35, 35. It is provided that recognized non-dash transport ferry, oblique ferries only can run within the distance of 3.2 kilometers on either side of the ferry. By further providing that the lessee shall have no claim for compensation or remission or refund of kissed money on this account. So accordingly, it is submitted that as by joint verification, the distance was found below 3.2 kilometers. The petitioner would neither be entitled to operate the ferry, ghat, nor he will be entitled to any compensation.
My lord, we have mentioned one more line in the impugned order
Yes,
that you are hereby directed to temporarily stop the boat service. So we have temporarily asked him to stop the boat service.
temporary, that's what I said.
Temporary.
Temporarily, I said. The stopping is temporary, huh? Page 36. Next one. Issue notice, including notice on the prayer for interim relief, returnable in 2 weeks. In 2 weeks. Requisite extra copies of the petition be served on the State and Department Council in course of the day. Next, the petitioner shall take steps within 2 days for service of notice on the private respondent numbers 6 and 7 by registered postal lady. In addition, notice be served by way of Dasti by routing the steps to the register of the court, and upon service an affidavit of service shall be filed prior to the next date of listing. Next paragraph. In view of the nature of preliminary defense taken, the court is inclined to put the respondents to notice as to whether at the time of tendering the ghat, the distance was more than 3.2 kilometers, and due to some reason, after the settlement was made, the distance of the two ghats were, two ferry service of the ghat was reduced to 2.7 kilometer. Moreover, comma, if that be so, comma, in the event at the time of tendering, comma, as per the records of the panchayat, the two ferries were at a distance of 3.2 kilometers, comma, why the court should not invoke public law remedy by directing damages to be paid to the petitioner. Next, list of the deeds.
Lordship, may I point out one thing, my lord? Before Lordship may put the notice of PNRD department only, because there is a notification of 2003, my lord. The PNRD has to take permission from the IWD department to plotting for any tender in the ghat, my lord. But they have not taken any permission from us.
We'll take instruction.
No, Lordship, I have a notification, Lordship.
Okay. Next one. The learned standing counsel for the IWT at this stage submits that notice be only issued, a notice for what you call for damages be only issued on the PNRD department. Though as per her instructions, comma, before prior to floating of any tender, comma, prior permission of the IWT is required to be taken.
As per notification dated 26/6/2003.
As per notification dated
26/6/2003, my lord.
2003. Full stop. The notice for damages is only issued to the PNRD department and authorities thereunder.
My lord, I'm deeply obliged, my lord.
Obliged.
টিফিন কি আজি টিফিন কি মাছ না মাংস কি আছে কাঠের সবজি ঠিক আছে আমি খাই এটা ঠান্ডা বই গো দাম দাম বলে না সারা করে ঘন্টা দাম দাম বলে না আপনি সার্ভে বলে
Yeah, yeah, I was there. I see the work. Then check somewhere else.
This matter I have checked, it is under section 147, Lordship. And I have asked one of my colleague also for dual confirmation. So it is 147 lordship. Subsection A.
Yes, this is the correct. Yes, Mr. Sarkar.
Lordship, there is a provision that appeal under 146, 151 under Assam Land and Revenue Regulation, Lordship.
Yes.
But Lordship, here the defendant, Lordship, that the Land Advisory Committee has passed the order, though the petitioner library was established in the year 1965, and there is a record, the official record disclosed that since 73, the land have been possessed by the petitioner library, and without giving the opportunity of hearing, Lordship. That's why under 226, Lordship, we have filed this, Lordship.
No, you see, the land must have been allotted,
Lordship.
but the issue is that unless your name is recorded in the land records,
Lordship,
your existence is not there.
and no, Lordship, the annexer 1 and 2, kindly Lordship will see that annexer 1 and 2, that the circle officer, he himself issued the notice or certificate of possession as well as holding, Lordship. Lordship will find that page 22 also, that in the year 2015,
No,
he
correct.
certified, Lordship. That,
Mr. Sarkar,
Lordship,
you see, X has a land.
Lordship,
He allows Y to remain there.
Lordship.
So what happens is still there is permissive possessor.
Lordship,
So does the right of the principal go away?
Lordship.
Then
And suddenly in 2022, without giving any opportunity of
no, you are not
hearing,
required. You
Lordship,
see, you'll have to show that you are required under the land and Revenue regulation.
Lordship,
You are required to be given any notice.
Lordship, Lordship.
You're not a owner within the meaning of the Assam Land and Revenue regulation.
Lordship. Hence, we have come before this
You
honorable
can't
court.
do anything. You'll have to go in appeal.
Lordship. Lordship, if direction is there, obviously, Lordship.
But Mr. S.K. Sarkar will transfer to the petitioner. And Mr. C.K.S. Barwal, an government advocate, appearing for respondent numbers
2 and 3 lordship.
2 and 3, and Ms. G. Hazarika, and government, standing also for Revenue Department. Revenue and Disaster Management, appearing for respondent number 1. Next one. The petitioner claims that the public library was established by the petitioner in
1960.
the year 1973-74.
Established in the year 65, Lordship, but land record says since
No,
73.
where have you stated that is 65?
Lordship, in our petition, Lordship, that we,
No, para 1 says you were established in 73. If you are established in 73, how can you open a library in 65?
no, Lordship, there are some averments are there that in 1965, Lordship.
No, but 65, how, you are not there.
And
How you
para
could
3,
establish-
Lordship.
How you could have established when you are not even born?
We established in the year 1965, but land record says 1973-74. Prior to that, there is no records found, Lordship. Established in the year 65, but land record says that 73 to 74. Prior to that, no land records were found, Lordship. The annexer 2 says, Lordship. Lordship will kindly see page number 20, Lordship, 22. Their certificate, Lordship. The said land is recorded in the name of Nolibram Library since settlement operation 1973-74. Records prior to that are not available in this office, Lordship.
No, that is okay, but you
Lordship.
see.
But library was established in the year 65, Lordship.
You can't assume that. We can't assume that.
Lordship, Lordship.
There are two reasons. Number one, while you were arguing, I was reading page 19.
Lordship. Lordship.
Correct.
Lordship,
This is an affidavit where you have said that this is a matter of record.
Lordship,
Para 3 is matter of record, according to this affidavit. Correct.
Lordship,
Your age is 32 years. Established in 65 will not be within your knowledge.
Lordship, Lordship,
So that's why I said there are two
Lord.
reasons not to accept your statement.
Lord.
Notwithstanding the claim of the petitioner that the library was established in the year 1965. First of all, the petitioner claims that the circle officer had issued a possession certificate in favor of the petitioner. And that the land advisory committee, where is that?
Lordship at page 49, Lordship,
49, that the
held on 8/8/2022.
that the subdivisional land advisory committee in its meeting held on 8/8/2022 had resolved to allot land in no, allotment, you said that you were allotted land. Where is that?
Lordship, at page 50, the committee allotted the land,
In
In
favor of
the-
Tiva?
Lordship.
No, in your name, you said that there was an allotment.
No,
Where is
no
that?
allotment, only certificate were issued, Lordship.
Oh, okay.
And that is why the impugned allotment order,
Okay.
Lordship.
So it is claimed that it is posited that the subdivisional land advisory committee in its meeting held on
8/8.
8/8/2022 had allotted the same land in favor of
Respondent number 4, Lordship.
Tiva Christie Bhavan, KRISTI Bhavan, within bracket Nalani Pam, NALANIPAM. According to the petitioner, agreed by the said recommendation for allotment has approached this code regarding this repetition of the Article 226 of the Constitution of India. Next paragraph. The learned government advocate has submitted that against any order for settlement, an appeal lies before the Assam Board of Revenue under Clause A of Section 147 of the Assam Land and Revenue Regulation, 1886. First one. Next paragraph. The as the subdivision land advisory committee in its meeting held on 8/8/2022 had approved the proposal for allotment of land to the respondent number 4. Where is your representation?
Lordship, there are several representations, Lordship. Lordship will find at page 24 onwards, Lordship, page 24. Several representations made before the DC as well as circle officer, Lordship, that they are dispossessing us and they are unauthorizedly, before the meeting held, they started construction. Likewise, we filed several representations, Lordship. Even we lost FIR also, Lordship.
No, Mr. Sakar, these things doesn't help me.
Lordship.
None of your statement is helping me. You just has approved it. And therefore, it would be appropriate that the petitioner makes representations before the appropriate authority against the approval granted by the Subdivisional Land Advisory Committee on 8/8/2022. Even if after the formal order of settlement is passed, it would be still open to the petitioner to prefer an appeal under clause A of section 147 of the Assam Land and Regulation, 1886. So accordingly, the court is inclined to close this petition with liberty to the petitioner to avail appropriate statutory remedy as provided for. So the opposite observation, the petition stands closed. Mr. Sarkar, that doesn't help me because of the reason that you are writing since 2014, but after the approval in 8/8/2022, after that you don't give any representation.
Lordship, highly obliged, Lordship.
Not so much.
Yes. Item 3.
Wait, please, Your Lordship. I'm sorry, Your Lordship, I was on Lexus at that time.
No, but
Otherwise,
when-
matter is covered, but my learned friend has raised question of territorial jurisdiction, Your Lordship. Petitioner has impugned the demand notice issued by my lord, DRM NF Railway, Katihar.
Definitely will not have jurisdiction.
How it is, it has jurisdiction, Your Lordship, because I am here before Your Lordship. May kindly come to first page 126 in my lord. Before that, my lord, brief facts I would like to place, my lord. Petitioners, my lord, engaged in the business of, my lord, manufacturing of sleepers meant for, my lord, railway track, Your Lordship. And for making that sleepers, my lord, in 1992, NF Railway Guwahati, my lord, they have allotted land because, my lord, why they want that land should be of railway for their convenience, so that it can be loaded in goods train and it can be transported. So on lease, they are, my lord, land was allotted way back in 1992. Subsequently, my lord, it is continuous process. It was going on. Page 126, my lord, kindly see once again.
Yes.
This award was awarded by, my lord, Northeastern Portian Railway, Maligaon. My lord, may kindly note it. And Your Lordship may kindly come to, I am taking Your Lordship to page 144. And Your Lordship will see clause 23.
Yes.
May I, Your Lordship? Law governing the contract. The contract shall be governed by laws of India being in force, irrespective of place of delivery, place of performance, or place of payment under the order shall be deemed to have been made at the place from where the acceptance of tender has been issued at Guwahati. There are jurisdiction of courts. The courts of place where the contract agreement has been signed shall have the jurisdiction to decide any disputes arising out of or in respect of the order. In support of that, my lord, I would like to rely two decisions, my lord. First, my lord, reported in, it is Excel Dilcom, reported in 2015, 8 SSC 291. And another one, my lord, Naval Kishore Sharma. First, your lordship may kindly see Excel Dilcom, my lord, 2015, 8 SSC.
Just we're going to the decision, Ms. Sharma. What are the grounds on which territorial jurisdiction is invoked? This question.
Lordship, Your Lordship, the petitioner firm is from West Bengal, Lordship, and the impugned demand notice, although the contract agreement is signed by the Chief General Manager, Northeast Frontier Railway, Lordship, the impugned demand notice page 229, Lordship, that is from
Katihar.
Katihar, Lordship. the divisional railway engineer, NF
NF
Railway
Railway.
Katihar,
Because
200.
29.
29.
This is the impugned demand. NF Railway. Your Lordship.
So impugned demand notice is from Katihar, which is in the state of Bihar. And the petitioner is a resident of West Bengal, and the company is also from West Bengal Lordship, registered in state of West Bengal Lordship. Except the NF Railway manager, because he is being the chief general manager of NF Railway, he had signed it. The seal of this is from Maligaon, Guwahati Lordship.
The agreement says, Mr. Goyal has pointed out the clause 23, 23.1, 23.2.
And 24.
So this agreement will always prevail.
And I am seeking my invoking of this contract, Your Lordship. That demand is not in terms of contract entered into by us, Your Lordship. Page, my lord, first, Your Lordship, may kindly come to page 1992 when we entered page.
No, you show me the facts first. This clause will come later.
Your Lordship. So we have entered into an agreement, my lord. Accordingly, time to time, my lord, works were allotted to us. And my lord, initially in the year 1992, my lord.
No, but in the petition where you have said that this is a dispute within the meaning of the contract.
Yes, Your Lordship, Your Lordship may kindly come to.
Because here, all references, all references are there with regard to the, some circulars, this is based on certain
My lord,
circulars.
page 8, Your Lordship, may kindly see. Para 4.
Yes, please read that.
That since 1991, the petitioner was executing different contracts for manufacture and supply of monoblock pressed concrete line sleeper to railway. Clause 21 of the contract dated so and so prescribed as under. This is my licensing, how they will give me license. Thereafter, Your Lordship, is copy I have annexed to Your Lordship. Thereafter, Your Lordship, may kindly see. This is a circular in respect of license, page 10.
Just demand notice is 2 to 9.
Para 7, Your Lordship, may kindly see. It is in respect of my lord license fee. It is in terms of my lord a contract entered into by us. This is a circular issued in respect of leasing of land, Your Lordship.
No, this will not be covered by the agreement.
No, this is the circular. Thereafter, my lord, kindly come to page.
Come to page 229. This is not a part of your, this is not a part of your agreement.
My lord, this is additional land.
Additional land can't be covered by the earlier agreement.
My lord, it is in agreement that I will show your lordship. My lord, in railway, for loading and unloading, that your lordship, page 19.
Page
19. This is the agreement dated 11/2/1992, loading and dispatch. Your lordship has got it, madam, that I have quoted. Loading of concrete sleepers in railway wagons shall be permitted in goods sets or otherwise available siding at work station. Wherever siding facilities are available, the same would be made available for the purpose of loading of the sleepers by contractor. If siding facilities are not available, the same would be provided by railway to facilitate loading of sleepers to the extent considered adequate by purchaser. No placement or siding charges shall be levied for such siding facility in both the cases. Erection of so shall also be permitted, the work being executed by contractor at his cost as per the direction of purchase officer. No license fee, page 20, my lord. No license fee or any other charges would be leviable on the contractor for installation of the aforementioned loading arrangements and their ancillaries and their operation in discharge of contractual obligations.
on the completion of the control work, the above mentioned loading arrangements with the ancillaries shall be removed and the railway providers restored to their original condition to the satisfaction of the purchase officer whose decision in this regard being
Where is your letter for additional land? Where is that?
that I am coming, your lordship. In the impugned letter itself, your lordship will see allotment of additional subject, my lord, can you see page 229?
No, you see, there are two things why I'm asking Mr.
My-
Goyal, this question.
my-
Number one,
My,
if it is a part of the agreement,
my lord,
then arbitration clause at page 173,
true, your lord.
that will prevail. Number one, it will not be a constitutional issue.
My lord.
The second is that if the land is not covered by this agreement,
Right.
then your jurisdiction is not here. That is the reason I'm
Covered,
asking
covered,
that
my lord.
question.
That's why it says, my lord, subject allotment of additional land on license for slipper factory at NJP measuring 0.8 acre.
On
adjacent
license
to
mean-
add,
On
exist-
license mean, it will be a new license,
no, my lord.
not existing license.
Earlier existing license, existing land under occupation.
Correct.
So we are in possession since 1992. It is in addition to that, my lord, it is allotted, and there is a provision to for
No, you
allotment,
see, we don't know things. I'm just asking you.
my lord.
Supposing you are given what you call 1 kattha land, correct? But you are utilizing 2 kathas of land. So therefore, they are saying that for this additional land, you come to an agreement. That they are saying, number one. Number two, it can be that since you are occupying this what you call, there's another matter where what you are saying is that you were allotted 2 kathas of land, out of which the entire land is used for this
Concrete.
the industry as well as for loading and unloading purpose. So
My lord, same question came up before this honorable court, my lord. Same question, your lordship. Even assuming, my lord, it is not free of cost. In that case, my lord, railway board circular that your lordship will see at page 222, my lord.
Mr. Goyal, you see this this page 173
Page 170.
to 29031. In the event of any dispute or difference between the parties here to or the construction or operation of the contract, if the dispute relating to construction of agreement, whether this land includes the free land or it doesn't include a free land, that's
My
the
lord.
interpretation of the agreement.
Number one, your lordship. Number two, your lordship, what I'm saying, even assuming, my lord, this is not, my lord, that in that case, my lord, railway board has issued master circular that your lordship will find at page 222, my lord. And I am taking your lordship directly to page 224. May I read your lordship? Fixing of land value. A market value would, however, be required to be taken to serve a base value for working out rental fee payable. This shall be fixed on the basis of the land value of the surroundings area as on 1/1/1985, as determined from the revenue authorities or from the following. My lord, same question came up before this honorable court, and this honorable court interfered with, my lord, the demand notice, and matter was remanded back to, my lord, authorities for recon. That your lordship will see, I have annexed judgment, page 237, my lord. In the case of the engineering, they are also doing, my lord, same business, page 237, your lordship.
Yes.
And my lord, after considering, my lord, fixation of land, para 5, after taking note of this master circular also, my lord, para 8, para 10, and this honorable court at page 241, my lord. Para 15. At this stage, it is relevant to reiterate that it is the mandate of all the circulars.
Just a moment.
My-
Just a moment. Before reading this judgment,
My lord.
in this agreement, where is the area of land written?
My lord, it was subsequently allotted that later, my lord, I have read. This is not in record in their own letter, page 120, your lordship may kindly see. License people, we are regularly paying your lordship. In fact, page 120, your lordship will see. License fee for land measuring, it was later written in 2005.
3.09 acre.
Human license, my lord.
Yes.
For that, my lord, demand draft, your lordship will see at page 121. Subsequently, also your lordship will see demand drafts are there. Series of letters are there, my lord. So this is not in dispute, my lord. 3.0. Still, I am, my lord, engaged in, my lord, that land is with me, and I'm manufacturing, my lord, sleepers in 3.01 acres of land. My humble submission is this, my lord. Let them, my lord, decide it, but on the basis of the master circular issued by. At this stage, my lord may issue notice. Let them reply, my lord. Till then, my lord. In the engineering case also, my lord, it was allotted way back in 1991. My lord, in India, 4 or 5 companies are, my lord, manufacturing sleepers, my lord. In fact, in the year 2006, also they allotted it. We have paid, my lord.
Additional land.
Additional land. That statement I have given, my lord. Para page 20. In the present additional land measure, in fact, they have allotted 1.26 acre of land out of, my lord, 1.426, 0.46 acre. It was given to back to them because it was not required. It is mentioned, your lordship. It was given in the year 2006. It is not that given recently. We are paying it regularly. It is not that we are not paying it. But it has to be as per the circular issued by Railway Board, because we are also doing in public interest, your lordship.
What is this?
This is given
Lordship,
by my.
it is my instruction, Lordship.
That I don't know, my
So
lord.
now it will be governed by Lordship. Page number, I have page mark it, Lordship, page number 11, Lordship. Page number 11, Lordship. To enable integrated development of infrastructure signed with PM Gati Shakti framework and to attract more cargo to rail, the extent policies for leasing, licensing and right of way of railway land have been simplified. The detailed guideline on policy for management of railway land, suppressing all previous policies, guideline, instruction on the subject of lease, license, way, leave, right of way are enclosed and annexation. Lordship, as per this Lordship, this page number 2 Lordship. So as per this Lordship, page number 3 Lordship, it also,
Just 1 minute.
yes.
Mr. Goel, you see, there is a reason for not entertaining this repetition here. Number one, you see, in this page 237, that judgment you are referring to of this court, by a coordinate bench of this court. Number one, here also the same proposition has come that if you don't have an agreement, therefore you will enter into an agreement. Correct. Now, if you are required to enter into an agreement, that means the court has not taken cognizance of the existing agreement. This court,
in that case, there was no agreement. That's why
no, no, whatever be, but the fact remains that in this agreement, this earlier arrangement, if any, was not taken into cognizance. Therefore, it says that you will have to. Here also, I think there is an agreement, because here it says that the original agreement, original land allotment was something less, but it was the land in occupation was 4.19 acre. This is what the case is here. You see, here it says that you were allotted, the petitioner herein, in this case, was allotted a plot of land measuring 3.13, page 237, 3.13 meter into 60 meter. But actually, they are in occupation of a larger plot of land. Correct. Now, that presupposes that the earlier allotment was not taken into cognizance, and therefore the court says for additional land you enter into an agreement. If that be so, from the same ratio, it appears that in this case the agreement was of Guwahati. The additional land cannot be a subject matter of an agreement which was entered here. It's not a part of it, and therefore it would not be here. If it is a case of additional land, then it must be determined in accordance with law.
My lord, your lordship may kindly see in the impugned demand itself, page 230. It was allotted in this, they are demanding not for recently, my lord, it is way back in 2006-7, your lordship.
No, you see, a demand I can make for whatever amount I like, correct? So somebody says that I would like an amount of rent from so-and-so. But in this case,
My lord.
your allotment of land is very clear.
Allotment of additional railway land on license for sleeper factory at NGP measuring so-and-so adjacent to existing land under occupation of PCM cement concrete.
Correct. You see what happens is that
My lord.
in this agreement, this easement was never there. So you are saying that under the land policy, we were entitled to the additional land for the use of the railways, and for that they would not charge any.
Not charge, even they are charging it. It is as per master circular also.
Correct.
And so far as additional
therefore-
land, my lord, additional land can only be allotted if I have factory there, and factory can only be, my lord, as per the agreement, your lordship. It is,
But still, it's an agreement, additional land. It's not covered by an
Additional-
agreement.
my lord.
Still,
It is
an
only for
additional
the
land.
purpose of loading and unloading and dispatch. That clause is given in the contract, my lord.
You see, you're not getting my point. Number one, even if I accept all your argument, what the court will direct is, according to the last judgment you have cited, is that you enter into an agreement with a new, with the new thing. If I am directing you to enter into an agreement, means that it is not covered by the earlier agreement. As simple as that.
In that case, my lord, there was no agreement. That's why. Here there is agreement.
There's no
My lord,
agreement. No,
that is-
it's not there.
My lord, kindly see.
No.
In the-
You see, in your agreement, it is mentioned. The
Your
land
lordship
which is,
Kindly see, there is no agreement.
yes, there is agreement, it's
In earlier
mentioned.
case, your lordship.
No, in this case, there is an agreement.
Your
3.19 or something acre of land was there, and you are holding up 4 point some.
That is
acre.
additional, my lord. 1.26 was given, my lord. Out of 1.26, my lord, 1.46 it was taken back, my lord. and 1 point out of now it remains on 0.8.
So original, there is an agreement for an original settlement.
My lord, here you also will see in the judgment, since there was no agreement, that's why this court directed. Consequently, in view of the
Even if there is an agreement,
taking
even
into
if there is an agreement for additional land, I can't say that it's a part of the earlier agreement.
my lord, they are allotting land because of the existing land. Otherwise, they will not allot it.
No, that can be, but it doesn't make a part of it. You see, let me say it very simply, which everybody will understand. You see, you purchase a plot of land measuring 1 katha, which is surrounded by other pata land. Now you want a road for ingress and ingress. You have to go to the main road, and therefore you require easement right on certain road. Can I say that it's a part of the same agreement?
Has been allotted because of the contract entered into by us. Page 36, my lord, kindly see. Page 36. Occupation and use of railway land. The contractor's request for making available reasonable area of the railway land for his work site of his stores, labor, hutments taking place for material and any other purposes connected with the work will be considered and provided by railway free of charge on such terms and conditions that may be prescribed by purchaser through the purchase officer. So whatever they are, my lord, this is in connection with one of the work which we are executing in terms of the agreement. It is connected with that agreement. If this is not that it is outside the agreement, it is whatever I am doing, my lord, it is as per the agreement. Let them file affidavit, my lord. Everything.
No, why should I entertain it? Why should I ask them to give an affidavit when it is not subject matter covered by your agreement? If it's a part of agreement, then it's a question of interpretation. You go to arbitration.
My lord, in that case, give me 1 day time, my lord. I will.
In fact, Lordship, my instruction also there, Lordship, that it's a matter of arbitration.
No, let him take
Arbitration, my lord. Arbitration clause is, my lord, not alternative. I'm read court. There cannot be any alternative to read court, my lord. And in case of my lord, there are decisions, Siemens and all, my lord. I can approach if there are prima facie, my lord, violation of.
You make your argument,
my lord.
We'll take it up on Friday.
Friday, my lord. Monday, your lordship may take up.
Next Monday. 19th.
19th.
Okay.
21st, your lordship. Monday, I have to go to 21st.
21st. Okay.
Till then, my lord, my lord.
No, it's okay. On the both sides are represented. Ms. B. Sharma Raman, CEC, raises a preliminary issue of maintainability on ground of existence of arbitration clause in the agreement. And it is also projected that the additional land is not covered by the existing agreement. Next, be that as it may, on the prayer made by Land Council for the petitioner, based again on in the motion column 1, 21/6/2023.
But till then, no worries. Till the 21st.
I am prepared to hear it.
My lord.
From January.
My lord, your lordship may hear and dispose it off.
I'll try to. I don't know whether I can dispose it off.
My lord.
Obliged.
Deeply obliged, my lord.
11.
Your case I am returning. Your instructions will get taken back. Yes. Item 11. Yes, you'll permit him to take out his goods that you can't destroy.
No, that's we allow him. Within the time, 3 hours time, within they will.
3 hours, I don't know whether I can clear my house in 3 days, 3 hours time, I don't know. Give them a reasonable time, at least 5 hours or 6 hours.
That 5 or 6 hours might be in office time.
3 hours is very
We'll take
difficult.
it and again we'll reseal it and again seal it, my lord.
You do it in presence of your officers.
Yes, no, our officer will be there.
Heard both sides will prepare for interim relief. At the outset, as it is projected in the impugned notice dated 4/4/2023, that there is an unauthorized construction of 2.49 square meter at the ground floor, comma, notwithstanding the plea taken by the petitioner that he had purchased the that she has purchased the space in the ground floor from the landowner. From the landowner. No, there is from the premises, the construction being authorized, being construction to the extent of 32.49 square meter being authorized. The court is not inclined to stay the demolition of the unauthorized part of construction. Nonetheless, comma, the court is inclined to accept the submission made by the learned counsel for the petitioner that prior to carrying out of the demolition of the unauthorized portion of the ground floor construction, comma, in case the petitioner approaches the Commissioner, Guwahati Municipal Corporation within 7 days from the date of this order, the Commissioner, Guwahati Municipal Corporation, within the respond number 3 shall fix a date and grant at least 6 hours time to the petitioner to remove his her belongings from the unauthorized part of the construction. And which shall be done in the presence of the officers of the officers of the staff of the Guwahati Municipal Corporation, and thereafter it will be open to the Commissioner from Guwahati Municipal Corporation to have the flat of the petitioner resealed. The petitioner shall produce a certified copy of this order before the Commissioner from Guwahati Municipal Corporation with an application with preferably within a period of 7 days from the date of the order. Next, in the meanwhile, the standing counsel for the GMC shall also send a downloaded copy of this order to the Commissioner GMC as an advance information.
Last word, Lordship, will say deseal, it will be resealed, my lord. First we will deseal it, then reseal it. Last word, Lordship, that deseal.
The GMC shall, Commissioner shall deseal and thereafter reseal after the after the removal of items. Just correct the language. List holds for the actual products.
51.
Lord, I have gone through this letter. This is only, my lord, the reference to the honorable court direction. And nowhere, my lord, the additional registrar asks the assistant registrar, my lord, to adjudicate the my lord, election dispute. And rather, the additional registrar cannot. Because the instruction says that till date there is no delegation of power. Reading both, my lord, the instruction and this letter, my lord, it cannot be construed, my lord. It is the option. Para 2 is very clear that till date no, my lord, delegation of power to any subordinate authority, my lord. And in fact, that letter was necessary because the ARCS, my lord, are the approving authorities to approve the election, my lord. So that is why, my lord, that perhaps the order of the honorable court has been referred to.
The same thing, I think this people will require to be briefed up. You see, that can't be accepted. I think Mr. Babu is right. Additional registrar forwards the copy of the order to take action. Therefore, he has taken action.
Perhaps, well, I don't know, there may be some miscommunication, but your lordship will see fundamentally, my lord, in fact, the assistant registrar could not have taken up the election dispute. And the, my lord, instruction, your lordship will see the registrar's letter. The second paragraph is very clear.
Then it has to go to the, Mr. Babu, I have no way. But this act has to be, rules has to be interpreted to mean that it will only be the,
Correct, my lord.
it will only be the election authority,
Yes.
no one else. I have to interpret this, otherwise there will be this problem always.
In this letter, my lord, there is no mention of our appeal, my lord, in this letter. There is no mention of the, for the appeal on the, for the.
No, no, anyway,
Whatever we, but so have to interpret it. But Mr. M.J. Kadir, counsel to the petitioner. And also heard Mr. S.K. Talukdar, standing counsel for the Cooperation Department, and Mr. A.M. Bodmia, learned counsel for respondent numbers 7, 8, 10, 11, 15, 16, and 18.
and for 1 to 5 minutes.
Sorry, 1 to 5, Mr. S.K. Talukdar. Next paragraph. The petitioners project themselves to be the shareholders of Mongalpur, Mongalpur, Bowali Hawar, BOWALIHAWAR, Cooperative Society in the district of Kachar. It is also projected that in the AGM election to be held on 28/1/2023, the nomination of the petitioners were rejected illegally. First, accordingly, the petitioners had opposed this court by filing WPC 395 of 2023. First, this court by order dated 25/1/2023 dispose of the petition with a direction to the petitioners to avail statutory remedy available under section 27 of the Assam Cooperative Societies within bracket election bracket close rules,
2019.
2019.
Yes, my lord, it's a section, my lord, it will be rule 25.
A rule, okay, a rule. Next one. The it is also projected that the AGM of the election was adjourned on 28/1/2023 due to lack of quorum, which was subsequently held on 4/2/2023, and the proceedings was approved by the Assistant Registrar of Cooperative Societies, Kachar. It will be Kachar, Mr. Kadir?
Yes, sir.
Kachar, on 10/2/2023. First off, challenging the conduct of elections, the petitioners had opposed the Registrar of Cooperative Societies on 7/2/2023 under section 27 of the election rules.
Rule 20. Rule 20.
Rule 27. First off, However, the Assistant Registrar of Cooperative Societies, Kachar, while impugn order dated 13/4/2023 has disposed of the appeal without interfering with the AGM of the elections held on 4/2/2023. The agreed petitions are before this court by filing this writ petition under Article 226 of the Constitution of India, amongst others, challenging the order on the ground that the petitions were not granted an opportunity of hearing.
My lord, that is not the case, my lord, because hearing was there, my lord, they are present, but it is not as per 27, my lord. As per rule 27, my lord.
Watcha, you are saying that it was not by the election authority.
Not as per 27, but that is one of the aspect, my lord. But that inquiry was not done properly, my lord. Properly on the basis of the perusal of the record not passed, my lord.
You were given an opportunity of hearing.
Yes.
Among others, on the ground that the matter was not decided in accordance with Rule 27
Yes.
of the Assam Cooperative Societies apostrophe election rules, 2019. Next,
also,
the
also as per order of this honorable court, my lord. Also as per order of this honorable court, earlier order, my lord, paragraph 13 was mentioned, my lord, that shall cause necessary inquiry, my lord, paragraph 13. This honorable court has mentioned, observed.
where is that?
Page number 74, my lord, paragraph 13. Paragraph 13, my lord, last line, the election authority shall cause necessary inquiry upon the disputes.
Okay, it is also submitted by the counsel for the petitioner that this court in para 13 of the order dated 25/1/2023 passed in WBC (395) of 2023 had provided that in the event an appeal of the representation is filed before the election authority by the petitioners, the said authority shall cause necessary inquiry upon the disputes brought before him on the basis of relevant records and pass necessary order. It is posited that despite the said observations, a necessary inquiry was not done, which has vitiated the impugn order. Next paragraph. The learned standing counsel for the Corporation Department has submitted that as per instructions received by him,
Second paragraph, ma'am.
As per government notification, wide number so and so, dated 3/5/2013. The power of election under section 41 within bracket 1 of the Assam Cooperative Societies Act 2007 is delegated to all additional registrar of cooperative societies, zonal joint registrar of cooperative societies, district Deputy Registrar of Cooperative Societies and Assistant Registrar of Cooperative Societies. Full stop, but comma. As per the Assam Cooperative Societies Election Rules, 2019, the power of election authority is vested only with Registrar of Cooperative Societies, Assam, and not delegated to other subordinate officers. Hence, it is submitted that it is that as per the provisions of Rule 27 of the Assam Cooperative Societies Election Rules, 2019, the adjudication of election disputes would only be heard and disposed of by the Registrar of Cooperative Societies, Assam. In this connection, the learned stenographers for the Corporation Department has referred to the provisions of Section 41 within bracket 1, read with Section 2 within bracket SA bracket closed of the 2007 Act, as well as Rule 27 within bracket B. Sorry, and Rule 27 of the Rule 27 read with which provision was that? F. Read with 2F of the Assam Cooperative Societies apostrophe Election Rules, 2019.
Lordship will also indicate 3A, the government can delegate the power, my lord.
Okay, it is also submitted
Section 3A.
that under the provisions of
3
Section
my lord.
3 within bracket A.
Subsection 2.
3
3 subsection.
Okay, 3 subsection 2
Well.
of the Assam Cooperative Societies Act, 2007, it would be the prerogative of the state government to appoint any other person or persons to assist the registrar by general or special order in writing, delegate to any such person or persons or any of the powers and responsibilities of the registrar under this act. So accordingly, it is submitted that it is only the state government who could delegate the authority of election, the power of election authority to any other official of the registry, of the registrar of cooperative societies.
To adjudicate election dispute, my lord.
To adjudicate election dispute, right. Next paragraph. Per contract, Mr. A.M. Borgia and counsel for the private respondents has submitted that the provisions of
They are submitted their appeal matter before the register.
It's okay.
Related to the application.
No, you said you referred to that provision.
Yes, sir.
You are referring to which
Three,
provision?
my lord. Rule 3.
Rule?
Rule 3, my lord.
Rule 3. As refer to the provisions of Rule 3. The 3A, in fact.
Yeah.
3A. Comma, which reads as follows. This is photocopy of 3A. So hence, comma, it is submitted that the assistant registrar of cooperative societies is a competent, was a competent authority, no, not was, is a competent authority for subdivisional level societies for the purpose of conduct of elections as well as the adjudication of election disputes. First off, it is also submitted that the petitioners had made their complaint before the additional registrar of cooperative societies.
The register directly, then it was
Register.
relegated to the my lord. Register relegated to the my lord district authority. That's in assistant register. This is my lord page, my lord 90, my lord also can you.
Page 90.
Yeah.
Okay, the complaint was submitted before the registrar of cooperative societies assigned. And the additional registrar of cooperative societies within bracket G, Assam, by his forwarding letter dated 23/2/2023 under memo number GPSS 12/2020/125 had forwarded the said appeal to the assistant registrar of cooperative societies future. Hence, comment is submitted that there was a proper delegation of power to the assistant registrar of cooperative societies future, and therefore there is no infirmity in the said order. Next paragraph. The it will be I have the consent for all of you to decide the matter.
Hello.
So at the outset, it may mention that the learned counsel for the petitioner, standing counsel for the corporation department, and the learned counsel for the private respondents. There's no objection is for the court to decide this matter at the motion stage. Full stop. Next paragraph. For the purpose of deciding this matter, it will be appropriate to extract the provisions of section 2 within bracket SA section 3 and section 41 of the Assam Cooperative Societies Act, 2007, as well as rule to H. No, sorry, it will be 2F. Rule 3 and Rule 27 of the Assam Cooperative Societies apostrophe election rules 2019. Next one. The Registrar of Cooperative Society of Assam, by his communication to the communication of the instructions to the United Standing Council for the Cooperation Department, has made it clear that the power of election authority is only vested with the Registrar of Cooperative Societies and not delegated to other subordinate officers. On a conjoint reading of the relevant provisions of the Act and rules extracted above, the court finds that on a conjoint reading, it cannot be said that the power to adjudicate on the correctness or otherwise of the elections held in a cooperative society could be delegated to the Assistant Registrar of Cooperative Societies, Silchar. Post of the provisions of Rule 3A, as extracted above, not make the Assistant Registrar of Cooperative Societies for sub-divisional level societies an authority to authority for it would not make this so as election authority. Within the meaning of section rule 2F of the rules, in the absence of any delegation of authority, no such order of the state government in writing to delegate power of election authority to any other officer has been brought on record. Next, therefore, in the considered opinion of the court, the act of the Registrar of Cooperative Societies Assam to send the matter to the Assistant Registrar of Cooperative Societies, Silchar, through the Additional Registrar of Cooperative Societies within bracket G, Assam, was not in accordance with law. Therefore, in the absence of any authority, to the Assistant Registrar of Cooperative Societies, Silchar, to adjudicate election disputes, not only the act of referring the of transmitting the appeal filed by the petitioner to the Assistant Registrar of Cooperative Societies, Silchar, is sustainable, nor the impugn order dated impugn order number 108. Order under memo number page 109. Number dated 13/4/2023 is consequently sustainable. Under such circumstances, the court is of the further considered opinion that there will be no point no purpose will be served to keep the matter pending for adjudication, and rather it would be in the interest of the members of the said society that the matter relating to election of the Mangalpur Boilawar Cooperative Society, Kachar, be decided as expeditious as possible, for which in terms of the order dated 25/1/2023, passed in WBC 395 of 2023, the court is inclined to remand the matter back to the Registrar of Cooperative Societies, Assam, to exercise his powers as an election authority under the Assam Cooperative Societies Act 2007 and Assam Cooperative Societies Election Rules 2019 and adjudicate the matter afresh, having regard to the provisions of section of rule 27 of the aforesaid rules and decide the matter within a outer limit of 45 days. Outer limit of 45 days.
By hearing all the parties.
By giving opportunity of hearing to the parties.
In fact,
Next,
sorry, sir.
yes.
In fact, as per the rule, he has to make an inquiry. The rule contemplates. To 27.
No, inquiry means it doesn't say how.
Yes. As per rule 27, not
As per rule 27, I have said.
Yes, not even said.
So you'll only give them an opportunity of hearing and 45 days. And then I say that accordingly to enable the petitioner and the private respondents to have an opportunity of hearing, it is provided that the petitioners as well as the respondents shall appear before the registrar of cooperative societies and by producing on we'll say 10 days from today. Everything is so. On 28/6.
Up to them.
28/6 without
On 27th, can you mind?
Huh?
On 27th.
27th you want. Okay, 27 6/2023. Without waiting for a notice to be served. And await further instructions from the Registrar of Cooperative Societies Assam. First of next paragraph. In respect of those private respondents who are not appeared, the Registrar of Cooperative Societies shall transmit a notice of hearing to those persons to the Secretary of the Cooperative Society for service to the to them or to any adult member of their family. Next paragraph. The representation stands allowed to the extent as indicated above at the motion stage without issuance of notice on the respondents. Next paragraph, in view of the nature of order which has been passed, issuance of notice on the non-appearing respondent numbers (9, 12, 13, 14, and 17 is dispensed with.
Well, I have some small submission. The letter of the registrar, my lord, 1623, that may be made part of the records. This which I have produced, my lord.
The next paragraph, the copy of the letter dated 1/6/2023 from the Registrar of Cooperative Societies to the Secretary to the Government of Assam, Cooperation Department, which is produced by the learned standing counsel for the Cooperation Department. It's made a part of the record. No, just as well as this, as well as copy of letter number GPSS post of 12/2020/125 dated 23/2/2023 by the additional registrar of cooperative societies within bracket capital G from Assam to the assistant registrar of cooperative societies, Silchar, as produced by the learned counsel for the private respondents, is also made a part of the record.
But only one aspect, your lordship has interfered with this order, impugn order, my lord, ARCS.
Yes.
So there is a consequence, my lord, of your lordship interference, because by this letter, the board has been approved to function, my lord. So that part also goes, my lord, now.
Yes.
So therefore, my lord, departmental officers should run the society now,
No, my lord.
because now there is no board.
No, there is no board.
Yes,
And
my
there
lord.
is an interim order made earlier of this honorable court, paragraph 15, my lord. Kindly, my lord, page number 74, paragraph 15.
What does it say?
It says, my lord, the new body shall not assume their office till necessary order is passed by the election authority.
No,
Paragraph-
after
paragraph
approval is done, Mr. Mr. Talukar is right.
Yes.
After the approval, there is a consequence happening. He's right in pointing it out.
So when government official, till then the government official.
Yes, there, my lord.
In the above, I've said interfered with the order so and so is present. So, as a sequel to the interference with the said order dated 13/4/2023. As the consequential approval made by the Assistant Registrar of Cooperative Societies to the newly elected board also goes, is also set aside,
My lord, may I
The-
clarify this figure, my lord? Approval authority is, my lord, assistant registrar, my lord. What he has done, my lord, he has clapped together two orders, my lord. His approval, my lord, and my lord, plus, my lord, the disposal of the appeal, my lord. He had
I
two orders.
understand, but you see that approval also has to go.
No, because, my lord, approval is separate, my lord, because election is there, my lord, and he has to approve, my lord. And my lord, election appeal is separate, my lord, but he has clapped together his two orders, my lord. One for approval order, my lord, under act, my lord, and another, my lord, appeal disposal order, my lord. So, my lord, this approval part is, my lord, separate thing, my lord. They are elected body, my lord, in the meantime, they will function.
Technically, is right.
No, why, my lord, he may not be correct, because, my lord, this, your lordship's order has to be read together with the earlier order. Earlier order says adjudicate the matter, till then, my lord, departmental officer. So since there is no adjudication under Rule 27, so therefore there cannot be the consequence or fallout, my lord, of the approval. So it's a continuation, my lord.
This is
This is what I understand, my lord.
my lord, this is there, my lord. It is provided earlier, my lord.
Okay, I'll think over. This part I'll think over.
All right.
Yes.
And my lord, in this order, my lord, one thing, my lord, I have seen, my lord, without referring any provision, my lord, simply it was relegated from the registrar. and, my
That's why
lord-
we are setting it aside.
Yes, my lord.
This is why this, no, you
If,
see,
my lord, any provision is referred, then your lordship.
I don't follow with him. The registrar says, send it back, he
Yes,
does it. They
Simply,
don't
my
apply
lord,
their mind.
prima facie, my lord, as per rule, he is the authority. But without any referring any provision of law, my lord, he has directly, my lord.
That is the mistake which is,
Yes, my lord.
which has been caused.
And my lord, I have seen, my lord, there is a gray area, my lord, in the, my lord, rule, my lord, 2F, my lord, and 3, my lord. Because we are conducting.
That is why I have
Today, your lordship is clarified, my lord.
That is why I have clarified, otherwise I would not
Yes.
run this exercise.
Yes.
I would,
My humble submission that my lord, paragraph 15 may be my lord considered, my lord, the earlier order, my lord.
Your lordship is not audible.
I'll take a break and come back.
My lord.
Date till 16/6.
This is the act, Your Lordship.
Yes.
Yes, Your Lordship. The
Thank you.
flag
I'll
mark
keep
page,
this.
yes, Your Lordship, the flag mark page has.
On each on same date, my lord, 28th.
Date term date is same. 5:30. Okay.
Yes,
I'll keep this. Keep this act.
yes, Your Lordship.
I'll keep this one.
Sure, Your Lordship.
Master.
And Miss
And Bordelais.
Anne Bordelais, standing counsel
And
for
Your Lordship. And
I'm sorry. Anne Bordelais, standing counsel for revenue.
revenue, Your Lordship.
Miss,
Respondent number 1.
only for one. And GMT, Mr. Asbara.
Yes, Your Lordship. He was here, Your Lordship.
Yeah, he's here. He's here. Asbara. For GMC and GMDA. Who are appearing?
4 and 5.
You'll be appearing? Acha, Mr. CKS Barwa and government advocate appearing for respondent number 2 and 3. And Mr. Bora, GMC, GMD for 4 and 5. Huh? Same order. Okay.
Lordship has fixed it on 28th.
28, same day. All these matters
And
will come on the same day.
they have to submit the representation within 16th.
Within 16th.
Okay.
But have you asked them to take
Yes,
a
yes, Your
decision?
Lordship. The 6th June order I have already communicated.
No. I was wanting that the state takes a decision, administrative decision, so
That
that
is-
this
yes.
we so that we don't multiply.
This way,
cases.
yes, Your Lordship, it will become.
Just try to have it done because today it's Mr. Barak, tomorrow somebody else may come.
Yes, Your Lordship.
Unnecessary, it can be.
I have communicated, Your Lordship.
Try to take, have them take a decision.
I'm obliged.
Same.
Same, okay,
Next item is also same.
okay. Ms. P. Bora for the petitioner. And respondents just check it out, huh? Same.
Same,
order,
Your Lord.
six.
Yes.
Doc number 630, 530.
530.
The phone number will be different. Madam.
Okay, just tell me the respondent numbers.
For one in the next item.
I've got two. MD two.
Jimji 2 and Mr. Barwa. 3, 4, okay.
I'm obliged.
69 bail hearing.
Yes, you got it?
My lord, I have seen the case record, my lord. From the case record, it has been seen that, my lord, the present status of the case is that the evidence stage is going on, my lord. And 2 witnesses has been examined, my lord. And there are 11 witnesses. Out of it, 2 witnesses has been examined. Moreover, my lord, in this case.
Just a moment. Mr. Islam, how many days today? 285.
388 days, my lord.
388 now,
Right.
okay. Out of 11, 2 has been examined.
On 19th January 2023, madam. On 19th of January, madam, two numbers of PWs, madam, has been examined. Madam. Thereafter, madam, another 1, 2, 3, 4, 5, another 5 days already, but no witness has been come.
5, after which date?
After 19th January, madam, another date fixed with 20 January 2023, 14th.
Just be slow. After 19, which
After
were the
19,
dates?
madam, date was fixed, madam, 20 January 2023.
20 January,
Madam,
20 January 23.
26 for evidence. Next, my lord, 14 February 2023 for evidence. Then 4/3/2023 for evidence. Then fixed 23/3. 23/3/2023 for evidence. Then 26/4/2023 for evidence. Then last, madam, 25/2023 for evidence. And next date is fixed on, madam, 21/6/2023, madam.
Achha, what has happened to this 124, this sessions case?
My lord, there is another bail verification file, my lord, that was listed before the court number 13, item number 6, my lord. I have today morning I mentioned praying for club together with this item, my lord. But that lordship court, my lord, direction to register to list them to.
No, it can't be listed here. You see, that is a jurisdictional court. I can't take up that matter.
Madam.
This other case will be unnecessary tagged here. Because if I have not rejected the earlier bail, I would not be taking up bail matters. Unnecessary, you made that prayer.
Madam.
You are required to just look at that record and find out the status. What is that?
Madam.
Today it was listed.
Madam.
Today the matter was listed. Item number?
Item number 6 in court number 13, madam.
I have no information at this point of time. I have no information, my lord.
No, take that information. That is why we adjourned it on that
No.
day. Because you see, he's a co-accused there also. So therefore, we adjourned the matter on 8/8/86 to enable you to go through that record and then tell us what has happened. Correct. So just go to 13, just find out about this matter, the status of the accused, because that case is relevant because of the fact that under similar circumstances, the driver of another vehicle was poisoned and he died. Correct. So look at that case diary and just tell us what is that matter about, because earlier also we rejected because of that, And today also there. Please go through the record and tell us. Come back and tell us. Mr. Islam, wait for some time. Yes.
This is an application for implement of a party, my lord. As a respondent.
Okay. Any objection? Ms. Sharma, Mrs. Sharma?
What the merrier, but my learned friend here prays for enhancement of compensation. This is an acquisition under the National Highways Act 1956, my lord. If I may most humbly draw your lordship's attention to section 3G5. That has to go to arbitration, my lord.
No, that is something else. But now he has come
Yes, my lord.
for impleading.
Only for implementing.
Impleading is like last time. NHI DCL PMU is said to be the correct authority.
That I have no.
General manager, can I?
Just a moment. Once Mrs. Sharma has raised the issue, let me just look at it.
Prayer is at page 13, my lord. Directing the respondent authority.
She's right. We'll implead it, but ultimately your case will be closed. This writ petition will be closed. You'll have to go through the arbitrator. Yes.
Pardon, my lord.
This matter has to go to the arbitrator under section 3G.
Before filing the petition.
Yes. my
No,
lord.
before you have already
They-
filed,
they-
so it's not a question of before filing. But you have an alternative remedy.
If the amount determined by the competent authority under subsection 1 or 2 is not acceptable to either of the parties, amount shall, on an application by either of the parties, be determined by the arbitrator to be appointed by the senior arbiter.
So on this, what do you have to say?
So, my lord, actually, my senior, Mr. Mondal, he is not available today. So today I have come for only implement of party respondent. By this
No, but
application.
statutory remedy is not availed. Without statutory being availed, we can't adjudicate. Okay. Heard Mr.
ATM Hussain.
ATM Hussain, done counsel for the petitioner, applicant. And Mrs. S. Sharma, and a government advocate appealing for
1, 3, 4, 5, and 6.
respondent numbers 1, 3,
4, 5, and 6.
4, 5, and 6.
2 and 4.
And Mrs.
1,
PR
3, 5, and 6.
1, 3.
1, 3, 5, and 6. my lord.
Okay. And Mrs. PR Mounted on it. The standing counsel for revenue department appearing for respondent number 2 and 4. Next paragraph. This interlocutory application is for impleading the opposite party number 8 as respondent number 8 in the connected writ petition. Next paragraph. Although the learned government advocate as well as learned departmental advocate have no objection to this interlocutory application, but it is submitted that that in the main writ petition, the petitioner has approached this court for enhancement of compensation without availing statutory remedy under as prescribed under section 3 capital G of the National Highways Act
1956.
1956.
My lord.
1956. The writ petition itself would not be maintainable in view of alternative remedy available. Next, whether as it may. Considering the fact that this is an application for impleading, this application stands allowed. And the opposite party number 8 is permitted to be impleaded as respondent number 8 in the connected writ petition. Next paragraph. What's this? in view of the preliminary issue raised by the learned government advocate on maintainability of this writ petition on account of alternative efficacious remedy available under section 3G of the National Highways Act from 1956. The petitioner is put to notice to the said preliminary issue. List after 2 weeks.
Like.
Just wait, just right. In view of the preliminary issue raised, comma, the issuance of notice on the newly implemented respondent number 8 is dispensed with for the time being. Next, however, in the meanwhile, the registry shall carry out the correction to the cost title of this writ petition in terms of order passed today in IA Civil so and so. List after 2 weeks.
Like.
16 for admission. 16 for
Yes, Mr.
admission.
Hussain, your matter.
Last occasion, my learned friend asked to take instruction.
3.
Non-payment or minor hiring charge.
This will allow the writ petition. Since 22, you are not receiving any instructions.
Yes, my lord, we wrote as recently as 19th of May, my lord.
19th of May, okay.
The last.
Heard Mr. A.K. Hussain, learned counsel for the petitioner. And Mrs. S. Sharma, learned government advocate appearing for respondent numbers 1, 3, 4, 5, and 6. For finance, who will be appearing? Mrs. Manta, you will be appearing for finance.
Gogoi was here earlier this morning.
I can appear on behalf of P9F.
Okay, Ms. S. Vidya, and counsel appearing on behalf of Mr. P. Nayak, standing person for finance department, appearing for respondent number 2. Next para. At the outset, the learned government advocate has prayed for some more time to obtain instructions, which is still awaited despite several letters, including last letter issued on 19/5/2023.
Yes.
Next para. The in brief, the case of the petitioner is that he owns a vehicle bearing registration number AS02T 4251, which was requisitioned by the respondent number 4. It is claimed that the requisition was illegal because at the relevant time, the vehicle was parked at the residence of the petitioner. And the vehicle was kept, was retained by the respondent number 4, i.e. the Superintendent of Police, Hojai. From 1/8/2017 to 10/4/2022. So it is claimed that the petitioner was given a part payment. However, despite making the part payment, an outstanding amount of rupees 18,47,810 is still due, which has not been paid despite requests and reminders. Next paragraph. In this case, notice of motion was issued by order dated 25/5/2022. But till date, the respondents have not denied their liability. And no affidavit in opposition has been filed to dispute the claim made in this writ petition. Therefore, the court is compelled to reject the prayer made by learned government advocate for some more time. And by drawing the doctrine of non-traverse, it is deemed that the respondents have jointly and severally admitted the claim of the petitioner to the extent of rupees 18,47,810 for part hire charges from of the vehicle from 1/8/2017 to 10/4/2022. Next, accordingly, the court is inclined to provide that while it could be open to the Superintendent of Police, Vijay, within bracket respondent to make an inquiry about the genuineness of the claim of the petitioner, about the admitted amount shall be released to the petitioner within an outer limit of 3 months from the date of receipt of a certified copy of the order. By his office. Next, the petitioner shall produce a certified copy of this order and provide the email address as well as phone number containing email, WhatsApp of the Telegram, etc. Just to enable the respondent 4 to
3 and 4, madam, I have been told by petitioner, bill has been forwarded to the office of the respondent number 3, Director General of Police. Normally, the money is to release by the DGP office of.
No, the Superintendent of Police will take care. He is the authority. He is the DDO in that district. He will take care of it.
That was sent to the DGP office.
No, those are only formal approvals. The DDO is Superintendent of Police.
Will he produce a fresh set of bills, my lord? Or the bills that have already been produced by?
Certificate copy. Along with his email address and phone number with containing WhatsApp or the Telegram, etc. Messaging applications like WhatsApp or Telegram, and also provide a fresh copy of the bill statement and proof of part payment made to the petitioner. Disposal.
I may be allowed to submit a copy of the order before the DGP respondent number 3 also, ma'am. So that they are convenient.
Okay, the petitioner is permitted to also serve a certified copy of this order on the Director General of Police assigned, and then respondent number 3. To bring the order to the notice of the said authority.
17.
Hello.
This is getting very electrocution. Petitioner's husband was working as a constructing labor of a house building, and there was some precaution measure that was not taken by the idea from the electricity board or from the owner. So that current.
Where is your complaint regarding the accident? Where is that?
My accident, I have filed an adjournment, that is an Annexure 1 page 12. Page 12. As you wish.
Who is appearing for APDCL?
Lordship.
And the
So for Lordship, so for the affidavit filed by the government Lordship electrical inspector Lordship, the report of the electrical inspector, it appears that the fault is from the petitioner side Lordship. It is not fault for the APDCL Lordship.
Where is that?
Yes, Lordship. The affidavit submitted Lordship.
Page 28, my lord. Twenty-nine, my lord, the first couple of lines.
Yes, Mr. Rashid, what do you have to say on this electrical inspector's report?
That is page 28. You kindly see cause leading to the accident. As in, last page, my lord.
I have read that. You said, tell us what do you want to say?
It is not my fault. It is the fault of the either owner or contractor. See, as the construction work was going on in near 11 kV divider, the owner
No,
of the
Rashid,
building.
Mr. Rashid, what has happened is once once the manner in which the events are narrated, that you were working in that building and you came into contact with the live feeder wire. So if there's a death of electrocution, insofar as the ACB is concerned, APDCL is concerned, you may not get any compensation from them if it is your fault. But nonetheless, you will be entitled to claim compensation under the Workmen's Compensation Act against the principal employer. But you have to satisfy the court that despite the report, you will be entitled to remedy against the APDCL. This is something you have to demonstrate.
Owner and the contractor, both I have made party, my lord.
In a writ petition, I can't pass an order, a writ against the private person.
Of course, yes, that is.
So
Either I have to go to civil court or the compensation, that is the your lordship.
WC, I think you either
Yes,
WC or civil court, whatever you choose. But to issue a writ against a private individual will be something you'll have to satisfy the court.
Then on that line, my lord, your lordship, I will appear with the file petition with WC, the workman compensation law. And if any delay, if any, that may be condoned in accordance.
No, I don't think there's a delay issue will be.
I have not worked my compensation, maybe delay, may not be delay. So I am saying there is no delay for a long time.
No, we'll exclude that period from this, from the date you file this writ petition, till date will be excluded from this limitation.
My lord.
But the requirement there is that you will have to serve notice under section 10 under the Workmen Compensation Act and then proceed. Heard Mr. A. Rashid Lanan, counsel for the petitioner, also heard Mr. J.K. Goswami Lanan, standing counsel for APDCL,
1 to 4.
appearing for respondent numbers 1 to 4, TO to 4. And you are government advocate?
Yes, 8 and 9.
Your name?
M. Sodhari.
M.
Sodhari.
Chaudhary. No, for the government, you will be appearing, Mrs. S. Sharma, then a government advocate appearing for respondent numbers.
7.
No, 5 also, 5, 6, and 7. Mr. Chaudhary, your name?
M. Chaudhary.
M. Chaudhary, then council appearing for respond number 8 and 9. Next paragraph. In brief, the case of the petitioner is that her husband
Husband name is Milord.
I have that name. Namely, Sahanur Islam, Sahanur Islam, was electrocuted through a 11 kV overhead live wire and due to electric shocks suffered, instantaneously suffered death. No, and while he was being treated, he died on the same day at Fakhruddin Ali Ahmed Medical College and Hospital, Kolkata. Just give the data I forgot, that on 16/3/2019 at about 9 a.m. the husband of petitioner number 1. That's what we continue. The petitioner at the time of his at the time of suffering the accident was working as a mason and was engaged in construction of a house of the owner of the building, namely Sahidul, Sahidul Islam. Within bracket, respond number 8. Mr. Chaudhary is only for 8. Stop. The petitioner number 1 lodged an FIR with the Baghpur Police Station, BAGH-BUR Police Station on 27/6/2019. And accordingly, Baghpur PS case number 196 of 2019 was registered under section 304 capital A, /34 IPC. Most of the deceased were the father of petition numbers 2 and 3, who are minors aged, or who are minors at the time of filing of this petition. First off, the petitioner number 1 approached the Deputy Commissioner Barpeta for compensation, and she was asked to approach the authorities of the APDCL for compensation. First of all, the learned counsel for the petitioner submitted that the owner of the house, namely no, there's some mistake somewhere. Oh, he's 8 and 9. This way, number 8 and 9. The owner of the house, namely Sahidul Islam, SHAHIDUL Islam, comma, the house owner, as well as the contractor, namely Hakim Ali, HAKIM, ALI Ali, within bracket as found number 8, had not provided for any safety measures for workers. First of all, the Learned Counsel for the petition also submits that the APDCL power line was very close to the house to be constructed, and therefore, even the APDCL is guilty of negligence. Next one. Accordingly, the present petition has been filed under Article 206 of the Constitution of India. So direct the respondent authorities to pay adequate compensation to the petitioners on the death of Sahanur Islam, SHAHANUR Islam, on 16/3/2019 in electricity accident at the house of respondent number 8. Yes, for contract, the Learned Standing Counsel for the APDCL has referred to the affidavit in opposition filed by the Chief Electrical Inspector from advisor within bracket respondent number 7 on 29/4/2023, and by referring to the detailed accident report dated 5/9/2022, has submitted that the categorical finding of the Chief Electrical Inspector, by the Electrical Inspector within bracket senior grade bracket post, was to the effect that the husband of the petitioner number 1 came into contact with the 11 kV feeder line and received fatal electric shock. First of all, it is also mentioned that the APDCL authorities were not informed about the construction work being carried out so as to have the power supply isolated. First of all, it is also submitted that there is a categorical finding to the effect that there was that the accident occurred due to non-compliance of regulation within regulation 64 within bracket 1 and 64 within bracket 2 of the Central Electricity Authority within bracket measures relating to safety and electric supply bracket closed regulations, 2010 on part of the victim. Next one. Having regard to the nature of report submitted by the electrical inspector within bracket senior grade, bracket was Government of Assam, exonerating the APD seal of violation of any violation of the contravention of any supply regulation, the court is of the considered opinion that no liability of paying compensation can be imposed on the APD cell authorities. Next paragraph. Nonetheless, it would be nonetheless, and accordingly, this writ petition stands dismissed. Next paragraph. Be that as it may, as it is projected in the report, in the detailed accident report submitted by the electrical inspector within bracket senior grade, dated 5/9/2022, the dismissal of the petition shall not be a bar for the petitioners to approach either the civil court or the employees compensation. No, what is it called? Workman's compensation.
Yes, workman
No,
compensation.
it's not workman, it's employees compensation. Employees compensation. Come. Metro Guwahati. Sorry, the jurisdictional employees compensation court to claim for having the claim for compensation adjudicated against the private respondents numbers 8 and 9. It's advised. Next paragraph. This petition was filed on 17/6/2022. And therefore, it is provided that the period spent by the petitioner in this court from 17/6/2022 till today shall be liable to be excluded from computation of limitation. If there be any approaching the civil court and or employees compensation court. As time spent before this court, which does not have jurisdiction, urges judiciary to entertain such complaint for employees compensation and or damages.
This matter to the chief electrical inspector has filed his affidavit. Lordship may turn to page 25, the last paragraph, and page 26, the first paragraph, causes leading to the accident. May I read it out? Madam?
Here also victim.
Yes, my lord. Pertinent to mention that the undersigned during his visit to the place of the accident did not find any wiring in the said room. Also, no earthing was found in the houses of the premises. If the proper earthing arrangement was made for the walls of the houses, which are made of CI sheet, then such an accident would not have occurred. And next page, my lord, causes leading to the accident. From the facts and circumstances leading to the accident, it appears that the victim died as he had mishandled the temporary electrical connection provided in his residence. Moreover, he was not a person authorized to perform electrical works. since he did not possess any electrical license, permit, etc., issued by the competent authority.
I have submitted reply to this one. Every reply has come.
What have you said?
But actually, we learned we are saying now we are safety measure. Safety measure, we have to-
Your reply is not there. Where did you file it?
I filed it we are on
I have not received a copy either.
24 May. Probably that is serial number previously lot 27 to 30. Then yes, 27 to 30 page number.
Page 29, paragraph 5.
I filed it on 24.
But Ms. Sharma,
My lord,
you see, last line you were reading, last paragraph
yes.
of page 25,
Lord,
it is pertinent to mention that the undersigned during his visit to the place of accident did not find any wiring, etc. in the said room. So if the wiring is not there, how he touched the, what do you call the electrical board?
Well, there was no, my lord, there was no earthing, my lord.
No, no. You see, for previous paragraph, as per statement so and so, he came into contact with the switchboard of the room, which was fixed on the wall of the room so and so. Second line, this is pertinent to mention the answered during visits did not find any wiring, etc. in the room. And also no earthing was found in the house. So if there is no wiring, how can there be electrical switchboard?
Well, here, mishandled, says. Was a temporary electrical connection, my lord. You'd like to say something? This was the report of the residents, local residents of the village, previous paragraph. Next paragraph, he says he has not found any wiring.
So there is no wiring. How could he
When he visited,
how he came into contact with a live wire?
So when the connection was given, electricity connection was given, they electricity government, they did not put any person, prevention.
Definitely they will not do. You see, you see, in this high court, when the live wire comes, it comes up to the switchboard panel. Beyond switchboard panel, they have got no liability for inside. For inside, it is the duty of the here the owner is PWD, therefore PWD does this wiring.
Even there was no earthing, they are saying, earthing should be installed by the authority.
No, they will not do it. They will just keep the earthing line. That is the third wire which they keep it there. And it is the earthing is provided by the owner of the house.
Yes, very well. And
owner is himself.
Our case I have seen they do not provide a line if there is not installed, earthing is not installed. That some plate or
No, that I don't know. But but you see this we will not go into that dispute because earthing is something which I can which I know. You see, please don't have any misgiving. This earthing has to be checked and rechecked from time to time because by passage of time, those things which are put into the earthing, they get polluted and it does not work. So therefore, for many reasons, even if you have a earthing at one point of time, it may not be available by a passage of time. You have to do it and redo again. That is why those mixture of coal and all, everything, those are put in from time to time and they are done. It can quite happen that you have done your earthing, even in your home when you go, just have an electrical electrician check your own wiring and you will find that maybe the earthing is disconnected for some reason. So,
That may be there.
so
No
therefore,
one's experience about
this
that.
is
No, no,
something
only
I-
I know that earthing is given by the authority.
this
and
is
they
something I have
taking that is
personal
also
knowledge
like
and
a-
therefore I know it about the earthing. But the fact remains is that whether if there's no earthing, it doesn't mean that the earlier earthing was not there. That is one. And second is,
Checking and checking also, that is their duty.
no, it's not. You have to show us.
We cannot trust if there is earthing.
You have to, that's why I'm giving you an opportunity to show us that that was their duty. The APTCL duty is not beyond the meter panel. You will have to satisfy me that beyond the panel, it is the ASB's duty.
But in this case, my lord, illustration from the my petition, then the petitioner's son will not, he touch the electric, will not that wire and connected with him.
Pardon me?
That
Pardon me, Mr. Rashid, I can follow you.
petitioner's son will not
Huh.
touch the electricity board or so will not, and that is not, he died in the house.
Correct. You see, just now I have touched this, what you call speaker.
Yeah.
I pulled it towards me. Supposing that this is electrified.
Right.
For some reason, there's an electrical fault and there's a, what you call, electricity energy passing through it. And if I touch it, I'll get electrocuted.
Yes, yes,
Maybe.
Now, this is not the fault of the ACB.
yes. Here in this case also.
But also report says that the required provision, that under
Because you
section
see,
Central Electricity Authority will not act, the regulation 2010. That is not provided forward.
because you see, the finding is that he has mishandled a temporary connection.
Yes, Lordship. That is the reason, Lordship. This is the roadside naked connection. It is roadside wire, Lordship.
I don't get it.
It is the come into the contract with the live naked wire on the roots. It is roadside.
You're reading where I missed it.
Yes, Lordship. It
Third
is
last paragraph, madam. Page 25.
Page 25. Second last.
third.
The one before that, madam.
One before.
Okay.
As per report furnished by.
As
the
per
subject-
report furnished, so and so. If the accident offers so 10% notice now came to contact with live naked wire on the load side.
Both side, madam, that's.
Load.
No, it is load side. It is right.
Load.
Correct language. Load side, when he tried to mishandle temporary internal wiring of his own house and got electrocuted, resulting to his death. Load side means it is prior to the meter.
Yes.
Yes.
Yes, Lordship. It's not a regular consumer. I think from this level, it appears that he is not the regular consumer of the APTCL, Lordship. He tried to connect the electricity connection to his house, Lordship, without having through authority, Lordship. Therefore, this is mishandled, Lordship.
Then, Mr. Rashid, this matter also has to be dismissed. The finding is, can I have your affidavit? It is said load side. Load is always prior to the metering system. Just give me that affidavit of yours.
I have one.
Page 4. Page 28, madam. Paragraph 4, the lordship takes them.
No, I don't have that affidavit.
It's, it'll be before your lordship. In the GP, madam. Page 29 of the lordships. Thereafter, respondent number 6 inquired into the matter on 7/9/22. Report after about 6 months. That cause of death was due to shock resulting electrocution during life. Deceased came into contact with live wire apparatus at his own residence. Electricity was not connected to the house as such. The incident took place. Deceased died to electrocution due to electrocution. The victim died due to improper connection of electricity. He's trying to say he has himself said that he didn't have a connection. Temporary.
Page 29.
So we can't do anything, Mr. Rashid. Your what you call your defense of there being no earthing also goes from here, because it is the load side connection which you have touched. So in the load side you will not get earthing. Earthing is only after the panel when it is rooted. Only then you get a what you call this earthing. Mr. A. Rashid, learned counsel for the petitioner. Mr. J.K. Goswami, Mrs. S. Sharma, learned standing counsel for the government advocate appearing for respondent numbers
5 and 6.
5 and
7.
5, 6, and 7. And Mr. J.K. Goswami, learned standing counsel for APDCL
1 to 4.
appearing for respondent numbers 1 to 4. Next paragraph. By filing this petition under Article 226 of the Constitution of India, the petitioner who has lost his son in a case of electrocution on 10/3/2022 is seeking direction upon the respondent authorities to pay compensation to the petitioner. Next one. The learned counsel for the petitioner has submitted that the son of the petitioner, namely late Monidul, Monidul, Hawk, aged 16 years, touched the fencing of the tin house of his maternal uncle on 10/3/2022. Which was which somehow came into contact with a live wire, and on touching the tin fencing of the house, the son of the petitioner was electrocuted. Accordingly, an FIR was lodged on 10/3/2022, and accordingly, Bagbor DGHBR PS UD case number 3 of 2022 was registered and investigated. First off, it is submitted that the APDCL authorities had installed electricity connection in the house of the maternal uncle of the deceased in a negligent manner, which did not have adequate provisions for earthing. And therefore, it is submitted that the petitioner would be entitled to compensation on the death of his son. Next, per contract, the learned standing also for the APD, learned government advocate appearing for the chief electrical inspector has referred to the report, detailed accident report dated 7/5/2022, submitted by the electrical inspector within bracket senior grade from our government of Assam. And it is submitted that the son of the petitioner had handled came into contact with the live naked wire on the inverted commas load 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 side inverted comma closed, when he tried to mishandle temporary internal connection in the house, which resulted in his death. So it is submitted that the finding of the electrical inspector within bracket senior grade was to the effect that there was non-compliance of regulation with 19 within bracket 3 on part of the victim, and 13 within bracket 1 on part of the supplier of the Central Electricity Authority within bracket measures relating to safety and electric supply within bracket closed regulation, 2010 on part of the victim. Electricity Act. There is this measures of security rules, measures of procedure rules. Where is the supply procedure rules? Where is that?
The gazette notification, so I have the notification.
Can you get me that?
Lordship.
Can you get me the this?
I downloaded it from the net.
To all of this, I may not be able to take up any other matter. Next one, right? The provisions of Rule 13 of the Central Electricity Authority You just said regulations 2010. 2010 regulations is quoted below. Next paragraph. From the report of the electrical inspector within bracket senior grade, government of Assam, it appears that the deceased came into contact with live naked wire on the load load side when he tried to mishandle temporary internal wiring of his own house and got electrocuted. First one. Uh, as per the statement of local residents referred to in the said report, the son of the petitioner, the head of the face of the son of the petitioner came into contact with a switchboard in a room which was fixed on the wall of room made by CI sheets. It's from however, when the electrical inspector within bracket senior grade bracket closed conducted the inspection, no earthing was. He did not find any wiring, etc. in the said room, and also no earthing was found in the house of the petitioner. Therefore, the son of the petitioner used to have handled electricity live wire, which causes electrocution. So therefore, court is of the considered opinion that the petitioner would not be entitled to compensation from the APTCL for the unfortunate electricity accident which had caused death of the son of the petitioner. As the son of the petitioner was found to have been handling temporary electrical connection in the house for which he was not licensed. Therefore, this petition stands dismissed. There shall be no orders to cause. The registry shall tag the affidavit filed by the petitioner on 24/5/2023 with record.
My lord, then
This bail, just a moment, bail matter. If he's there, yes,
I have seen, my lord, it is in the motion stage, that's a pass over the matter, and I have also seen the CD, my lord. The FIR is more or less the same, my lord. The modus operandi is same.
same.
Yeah, same, my lord. And it is also stated that in the PW1, my lord, who is the informant, he has also stated that the father has called her and stated that he came by a alto car. Here also alto car, my lord. And I have also seen the charge sheet, my lord. It is also stated that in the FSL report, it was due to poison, my lord. He had died. And in the aftermath of the incident, my lord, it is just also similar, my lord. He was found in the roadside and he was taken to hospital, and he was, after 4 days, he died, my lord. It is more or less same, my lord.
Your name, I forget.
KK Das.
KK Das. Okay, Mr. Islam. I pass others and looking at it. Yes, Mr. Chaudhary.
my lord, in item number 29, the interim is still today. They haven't filed the affidavit, so lordship may have it after the vacation. The only thing is interim needs to be extended.
Okay. Any other orders where interim has to be extended?
Or may I pray for a date, or fixed date, if it is not, on 19th of July.
Okay. Sharma, you give 19th of July. Okay.
Right.
Interim extended.
I'd like to mention item 62, my lord.
Just one time.
62, my lord. It is, we have filed an IAS comment, but it has not been reached today also. So, my lord,
What is the I for?
there is a interference of the order, my lord. They are constructing the line, my lord. That's why.
Okay.
Any date as per your convenience, but in updated condition, my lord.
You make a prayer on the next date, we'll upgrade it.
Yes, I will come day after tomorrow on Monday, my lord.
Okay, Friday.
Friday.
Friday. With liberty to Mr. S. Viswas, counsel to the petitioner to upgrade, to make a prayer for upgrading. Data.
My lord, I recommend item number 34, interim order is still today, my lord.
Just tell it to the court master one by one, he'll do it.
Yes.
We'll get it extended.
As regard item number 43, your lordship, matter may kindly be taken on 21st, my lord.
Just tell the court master, he'll look at the convenience and do it. Just give him some time. 21st, just give him some time after I rise. I'll do it.
Item 20, lordship. The department already filed their affidavit, lordship.
I'll just tell the court master, he'll send it.
My lord, item 42, lordship.
Lordship, may I make a prayer in item 60, Lordship? The service is to be accepted only, Lordship. The lodgement order is there. Only with regard to acceptance of service. Lordship.
On which respondent?
Respondent number 9, 7, 9, and 10. 7, 8, 9, 10. Lordship.
7, 8, 9, 10. That's not complete. That's what housing order. List in the admission column after week.
Lordship.